Any other questions, comments, concerns, things that we need to go over before we pick up where we left off, folks? Okay. So then here's the little bit of a recap. We are wrapping up units 9 and 10, and we'll just call it units 9 and 10 because we're really basically done with 9, and we're going to just jump right into 10 today, and that'll move pretty fast. So when I say 9 and 10, I mean from the syllabus, the old syllabus, which is where we're dealing with basic contract law. And I will remind you, do not answer basic contract law questions thinking about real estate. Valid, void, voidable has to do with contracts in general. Bilateral versus unilateral has to do with contracts in general. Okay? You've got to remember that when you're answering questions, you are either answering general contract questions, general real estate contract questions, or a very specific question on a very specific contract, like the difference between an exclusive agency listing agreement and an exclusive right to sell listing agreement, or very specifically what happens in the use of an offer to purchase in contract standard form 2T. So we talked about all the different things that contracts could be, and we talked about some of the verbiage. So let's just make sure you're feeling comfortable with this. In basic contract law, what does executed mean?
It's done. It will need to be performed.
Executed is done, completed, fulfilled. No, I'm sorry. Completed, fulfilled is executed. So now let's flip the coin. What is executory?
Needs to still be fulfilled.
There you go. We've got a contract, and there's still items remaining, and so it's not fully completed yet. That is an executory contract, okay? What about express? What does express mean? Say it again. Stated. Stated. Express means stated. We have clearly articulated what it is we're doing. So express could be orally spoken, or express could be in writing. The opposite of that was implied. It's formed an agreement based on our actions. The biggest example I gave you, sitting down at a restaurant. You know that when you sit down and you order food and you eat it, that you're going to have to pay for it. That is an implied agreement. Okay, then we got into unilateral versus bilateral. What's unilateral?
It means it's an agreement between two parties, but it's one party, one promise. Right.
There you go. Every contract, folks, don't ever let this trip you up on the test. Every contract has to have at least two parties. I told you it'd be a Weight Watchers contract is what I told you if you were trying to do it with one party. All right, and there ain't no accountability in that. You know what I'm saying? So two parties, but one promise. Now, what was the biggest example from a real estate point of view that I gave you that is a unilateral contract?
An option.
An option to purchase agreement. I'll give you this money to give me a period of time to decide if I want to buy it or not. And if I decide, that keyword, if I decide to buy it, you have promised to sell it. So if this, then you've promised that. And so the non-real estate example I gave you, if you mow my lawn, I will pay you $80. Okay, there's no promise to mow my lawn, but if you do it, I have made the promise for you to pay me, or for me to pay you. Now, we're going to get into a concept that's North Carolina specific in a little bit, so I'm going to hang tight on the tie-in, if you will, until you fully understand what I'm going to get into later tonight. So bilateral is just two promises. Now understand, even in an option to purchase where it starts as unilateral, if you do in fact exercise your option to purchase, now you are in a bilateral agreement. You have promised to buy, they have promised to sell. Most contracts are bilateral, okay? Most contracts are bilateral. Then we got into valid, void, voidable. What makes a contract valid? Just in a nutshell, what makes it valid?
It has all the elements.
Has all the essential elements of a valid contract. That's exactly right. How many of them are there? 4. What are they?
Agreement.
Mutual agreement, also called mutuality of assent, reality of consent, meeting of the minds, a lot of different names for it. So we got to have agreement. There's one.
Consideration or a compensation.
Consideration, something of value. There's two.
Legality.
For a legal purpose, there's three.
And 18 sane and sober.
18 sane and sober. There you go. Legally competent parties. Okay, the ability to contract. 18 sane and sober. And hell, 2 out of 3 ain't bad. I'm just kidding. For contract law, they have to be 18 sane and sober. Okay, for this class, 2 out of 3 ain't bad. All right, but for contract law, okay, all 4 of those. Now, is a valid contract under basic contract law always enforceable?
No,
No. Why not?
could be. I keep thinking of that mess.
Well, the meth is always a good example that it'll tie back. The reason that why that one's not enforceable is because it is for an illegal purpose, which would make it void because it lacks an essential element. But there's another reason why it might not be enforceable.
If it's an oral contract.
Because it was an oral contract specifically when the statute of frauds said it needed to be in writing. Now, all contracts have to be in writing. So let me just make sure y'all are good on this. There are plenty of oral contracts that, as long as they have those essential elements, are enforceable in a court of law. When I say enforceable, it means the courts will hear them. We can go to court over it. But because the North Carolina statute of frauds and many other states' statute of frauds states that certain things have to be in writing to be enforceable in a court of law, one of the big ones being contracts for the sale of real property, an oral agreement to buy or sell real estate would not be enforceable, even if it contained all the essential elements. Adriana, I want to buy your house for $800,000. There's consideration. Adriana agrees. We got agreement. Adriana and I are 18 sane and sober, and it's for a legal purpose. If we agreed right now that I was buying our house for $800,000, we could complete that contract, sure. But if one of us doesn't do what we said we were going to do, we can't take it to court because it is a contract for the sale of real property. And the courts in North Carolina say, we're not going to hear this. It should have been in writing. Does that make sense for everybody? So when I say voidable, what does that mean? What does voidable mean?
Means that something happened in the process of it being made, such as maybe being signed by a minor, where it can but does not have to be voided.
Yeah, it is presumably got all the essential elements, and it's enforceable probably on one party, but for some reason or another, a party might have the right to get out of it. Like Jacob said, a minor would be voidable. You did not have the capacity to contract, so if an adult signed and a minor signed, the adult could be held to it, but the minor could not, rendering it voidable. The minor has the right to back out. What's another example of voidable?
Someone breached.
Wasted, drunk, or
Drunk as a skunk, high as a kite. Okay? Not of sound mind temporarily. If you sign a contract while you're drunk, then you could potentially get out of it. Now you bear the burden of proof. Now I want to caution something here. I just heard you say, and this is where it gets a little iffy, and this is why I don't like how much detail we have to go into this. Somebody said if somebody breaches, well, here's a word of caution. If somebody breaches the contract, that does give the other party the right to typically get out of it. However, we wouldn't necessarily call that voidable. When you are trying to void a contract under your rights of it to be voidable, you're basically saying the contract never existed. And if you say the contract never existed, then that means you're not entitled to any remedies, which is what's on the screen right now. So you may have the right to terminate due to somebody's breach, but I would err on the caution and not call it voidable, even though sometimes we do teach it that way, but you just got to be careful. Because to void something is to say that it didn't exist. Let's go back to where we were. If you say that, then you're not entitled to remedies. Of course, you want to have your rights to your remedies under most circumstances. So, biggest examples of voidable, minor, and under the influence. What are the most common examples of void? We've already said one, the illegal act. What's the other one that's always void?
Underage.
Not the underage one. That's minor. That's voidable.
Incompetent?
There you go. Mentally incompetent. Okay, somebody who has been declared mentally incompetent by the courts. Britney Spears, while she was in her conservatorship, if she signed a contract, that'd be void. Your grandma who is under your guardianship signing a contract because she's got Alzheimer's, that'd be void. Okay, those are always void. Somebody who's been declared mentally incompetent. Minor voidable. They will ask you to differentiate these on the tests, I promise. Okay. So let's come back to where we left off, and that is contract remedies. A contract is a set of promises that are presumably enforceable because they have all these criteria, which allows you to take somebody to court if they don't do what they said they were going to do. Well, them doing what they said they were going to do is called performance. You made a promise, we agreed to it, now you're expected to perform. So if we have somebody who does not perform what they said they were going to do, couple different types of remedies exist. There is, as I said last week, monetary remedies. There is also non-monetary remedies. So the consequential damages, I think we had compensatory on the last slide. Let me go back and make sure we already covered compensatory. Yeah, compensatory damages. So the monetary remedies are compensatory, which means return me to the financial position I was in, compensate me, make me whole. I lost $6,000, repay my $6,000. That's compensatory damages. Now, do understand that if people won't willingly hand this over, this involves a lawsuit. Suing for consequential damages, suing for compensatory damages. So compensatory is return me to how much my financial position before you did me wrong. Okay? Make me whole is what compensatory is. Consequential, I told you, is where we seek damages for future or lost profits. Johnny Depp, Amber Heard is the most prevalent example there because Johnny Depp lost out on a lot of movie roles, a lot of potential money. He didn't lose any out of his bank account, but he lost future profits that he could have made due to her defamation. And it could happen in real estate. Now, the other big money damage, which I believe is on this last slide, so let me just circle back around to it because this is very important, was the liquidated damages. Liquidated damages are money. It's a pre-negotiated amount that says, if I mess up, here's what you get. Now, we're going to talk about earnest money in great detail today, but earnest money is liquidated damages. It's basically a pre-negotiated amount that the buyer says to the seller in North Carolina on our contracts, and other states for that matter, if I mess up, here's what you're entitled to, okay? Pre-negotiated amount. Now, the other remedy that comes into play that is not monetary, I told you, is called specific performance. I will caution you that specific performance is arguably for anybody. It is where you want somebody to specifically perform what they said they were going to do. You made a promise, fill that promise. So you go to court and you say, Judge Judy, make them do what they said they were going to do. For real estate, that means making people buy or making people sell houses. Now, in general, I told you it's for everybody. But if you're ever answering a question very specifically about the North Carolina Offer to Purchase and Contract Form 2T, very specific contract, it is only available to a buyer. And you'll see why later tonight. Now, to rescind the contract basically goes back to what we were just talking about whenever we were saying, to void it. To rescind is to basically say, let's pretend it didn't exist at all. And so that's not so much a remedy as let's backtrack and go back to where there is no contract, okay? To rescind, to void, to, go back to square one, pretend it didn't happen. Now, all of these remedies are, of course, subject to a statute of limitations. You cannot sue somebody for damages 40 years down the road for most things. It depends on what it was for, what you're seeking. You're not going to be tested on time limits for statute of limitations in any way, shape, and form. So here was the application challenge that we said we didn't get to yet, okay? And so, it's pretty long. I'll give you a second to kind of read through it and see what you think. Tell me what you think here.
I think it's true as long as they have it written down.
It's not written, it says verbally agreed.
Exactly, verbally. Right, verbally agreed doesn't count.
Oh, yeah,
False.
I misread the question. Yeah, false.
Now, let me provide a little bit of clarity here. The negotiation on the washer and dryer was a verbal negotiation. OTP&C is the offer to purchase and contract. That's in writing. So there is a written contract between them, but the washer and dryer negotiations were verbal.
Right.
I say it's true.
It is,
Seller is entitled to contract rent.
yes.
Yeah, let's talk about it. Okay. True or false, buyer and seller have verbally agreed for the seller to leave their washer and dryer, although this is not included on the offer to purchase and contract. Seller later decides to take the washer and dryer with them to their new house. The buyer is distraught and wishes to terminate the contract. The seller will be entitled to the contract remedy earnest money deposit if the buyer breaches the contract. Folks, that is true. If the buyer breaches, the seller would be entitled to a remedy. Remember, we talked about this. This is called the parole evidence rule. Only what's in the contract is part of the contract. And so in this instance, they have a written agreement, makes no mention of the washer and dryer. So the sellers are not in breach for taking that washer and dryer. But if the buyers terminate over something that was not in the contract, they would be in breach. And of course, the seller would then be entitled to the remedies. In this case, the earnest money deposit. Now, one last mention in regard to some minor testable items under basic contract law. Okay, I've been sitting here and I've been telling you that, contracts for the sale of real property have to be in writing. Well, let's talk about a very specific type of sale called an auction. You all have heard of an auction before. An auction is where people bid on different items. It could be, antiques. It could be, equipment. It could be cars. It could be real estate. And so auctions happen by somebody yelling out prices and people picking up their little sticks and saying, yep, I'm going to bid on it. Well, folks, I want you to think about this. If they're auctioning off real property, the statute of frauds in North Carolina says, well, hey, listen, these need to be in writing. Imagine how silly you would look with 17 pieces of paper trying to strike through your number and be like, 425, and then trying to fill out the contract simultaneously. Wouldn't make any sense. So because of the way that contract law works in conjunction with auctions, we kind of talk about that. Auctions are recognized as binding even though they're not in writing. Of course, they will ultimately be reduced to a written agreement for real estate. Now, a couple other extra notes here. The person who talks really fast is, I got 300, let me get 3025, 3025, 3025, and the next person 30, 30 in the back. That person is called the mere crier, okay? This is testable. Mere criers are referenced in our license law and commission rules in North Carolina as an exemption. They do not need a license. They are an employee of the auctioneer firm. So they do not have a real estate license. They do not have an auctioneer's license. They're just an employee who can talk really fast. So the mere crier doesn't need a license. However, an auctioneer company who is auctioning off real property would have to have both a real estate broker's license and an auctioneer's license. And because of the special nature of contract law with auctions, it is binding. When we say sold, it means sold. It will ultimately be reduced to writing as a formality, but it is binding even though it starts off as a non-written agreement. Now, the other thing that you may need to know about auctions, you've probably heard these terms before, with reserve and without reserve. Okay, with reserve and without reserve. When we say with reserve, it means we reserve the right to not sell it unless a certain price is hit. Without reserve means we will sell it for whatever price we get. So let's say the reserve is, $200,000 on a piece of real estate for an auction. If you only get up to 190, they're not selling it. If it's without reserve, they'll sell it for whatever they get.
Seth, will they call it a mere crier or will they just call it a crier?
Could be either.
How do you spell mere?
M-E-R-E. I'll show you real quick. So remember on day one, we kind of talked about some of the when a license is required, when it's not discussions, which fall under 93A-2 under license law. So I'll show you. Right here. So when we talked about those LOBs, right, list, lease, buy, exchange, auction, negotiate, sell, that's really outlined in 93A-2. So real estate broker within the meaning of this chapter, any person, partnership, corporation, limited liability company who lists or offers to list, sells or offers to sell, auctions or offers to auction. But right here, specifically not including a mere crier of sales. M-E-R-E, mere crier. Not to be confused with a meerkat.
What was that, Seth? Do that one more time for me?
So it's funny, I actually teach that in great detail in post-licensing about a meerkat, because when we talk about material facts, we have this obligation to discover and disclose, and so I always tell my students that they need to at least look in the crawl space and they need to check the attic. And so I'll tell my students, I said, you need to at least, I tell them they can use the phrase, in regard to the attic, I tell them they need to meerkat that son of a gun, which is where you just pop your head up in there, look around at least. So I always tell them that, because that's, you look like a meerkat. You just pop your head up in there, you know, look around. That's what I call it, meerkat in the attic. So if you take my, for post-licensing, you'll hear that reference again. So that is the basic contract law section, folks. So bilateral contract, two promises, two parties. Unilateral, two parties, one promise. Counteroffer kills the original offer and the roles switch. The offeree is now the offeror. Valid, void, voidable, we talked about already at the beginning of the day. Express means stated, could be in writing, could be orally spoken. Folks, do not forget that it's okay for some contracts to just be spoken. You are not answering every question as a real estate contract question. There are plenty on contracts in general. Plenty of contracts can be enforceable, even oral. Implied is suggested by our actions, and meeting of the minds is part of that mutual assent, mutuality of consent, reality of consent, mutual agreement, all those 10 billion names for voluntary under the 4 essential elements for a contract. Which leads us into the next fun-filled discussion. So now we're going to change gears. We've been talking about general contract understandings, the interpretation as a nation. It kind of rhymes. But now in Unit 10, we are getting into specific contracts and things relating to them involving North Carolina sales practices. Okay? Very specific to North Carolina. Because if we just say a sales agreement, that's just a blanketed term for any kind of sales contract. If we say, you know, purchase and sale agreement, that's a general term. But we're going to get into very specifically named ones. And so this is where I'll remind you. A question on a sales agreement, that's general. A question on the standard offer to purchase and contract form 2T, that is an extremely specific question you're answering. And I'm going to remind you why this is important. In a standard sales contract, destruction of the property would kill a sales contract because of impossibility of performance. If you promise to give me a house, I promise to give you money, and you promised we would close on it within 40 days. Folks, if the house burns down, is it still possible for you to give me the house as contemplated within 40 days? No. So in a general sales contract, that would probably kill it. because of impossibility of performance. However, you will find as we get into the specific 2T, which is testable from the North Carolina point of view, destruction of the property does not automatically terminate the contract. There is a specific provision in there that says it can survive if the buyer wants it to. You see the difference? You've got to be very thoughtful in how you're answering these questions. So this is all very specific stuff. If I'm referencing anything generalized, that goes back to national, I'll let you know. But of course, we're going to be talking mostly about North Carolina specifics in this section, okay? Well, I take that back. There is a couple things that are generalized, like the installment land contract, the option contract, things of that nature. And I'll point out when we're in which section, so nobody panic. So let's start with just some basic North Carolina rules that are testable in regard to these contracts, okay? Understand that the best way for me to articulate this is what I like to call stay in your lane, bro. When I say that, can we skip contracts and get into finance? Unfortunately, contracts and finance are equally testable. There is a crap ton of them. Although I am going to breeze through this because the North Carolina specifics, well, actually, that's not true. They've beefed up the stateside test. I keep forgetting that. Normally, I would very much breeze through this section. The problem is we just added 20 questions to the North Carolina side. So I'll be interested to see how those first couple test scores do. What you got, Jacob?
I am joking, but
I know.
I was wondering, you keep talking about the North Carolina 2T or T2 or whatever
2T,
contract. Is that the standard contract that we always use for the sale of real property here in the state of North Carolina? Or is that a specific contract that we can use in North Carolina? And if so, okay, so it's the second one. So when do we use it? When do we not use it? Or is it just a preference thing?
Hang tight. That's an excellent question. That's a really good question. Yeah. So let's start with a couple precursor rules, and then I'll answer that question because it's a really good one. And I'll provide some additional clarity. So when we're dealing with North Carolina, there are several laws and rules. Now, let's first start with the unauthorized practice of law. That's where I was saying stay in your lane, bro. We are real estate brokers. You are endeavoring to become a real estate broker. When we are dealing with clients and contracts, we are actually using standardized forms that are drafted by an attorney, and we are, ready for this, glorified blank fillers. The contract is already pre-printed. There are blanks that we get to fill in. Purchase price, closing date, due diligence amount, any closing costs paid. We're not drafting documents. We cannot go out and create our own contract. That would be what we call the unauthorized practice of law. Now I'm going to make an important statement for contracts, okay? If you draft a contract for somebody else, that's the unauthorized practice of law. But understand that any person in the world can write their own contract. Folks, if Jacob and I wrote out a sales contract on a napkin, it's fine. Because I'm one of the parties, he's one of the parties, and there's no legal requirement to have a formal contract. A contract between parties could be on a napkin with a ketchup stain, and it's still arguably probably enforceable. So what I mean is, we as real estate professionals helping buyers and sellers, we're not a party to that agreement, are we? We're a third party. So if we were to draft up anything, that's doing it for somebody else. That's the unauthorized practice of law if we do it. But if your buyer drafts up their own contract and they say, you as my buyer's agent, I want you to use this contract, and I want you to have the seller sign it, we could. It's completely lawful to utilize whatever contract or documents they want to draft up. Now that being said, folks, let me see if you can piece this together. We can't add any special language to a contract. We can't create a contract on behalf of our clients because we're not a party to it. But there is a contract that we could make changes to as a real estate professional. And add language to it. Which one?
Would it be the contract between us and the client?
There you go. The agency contracts. Because we are a party to it. Does that make sense? If we were to put in specific verbiage for us, where we're a party to it, that's not the practice of law. That's putting in verbiage for us. But because we are not a party to the sales contract, we can't write in any special language. So we use standardized contracts, one of which is the 2T, and we use standardized addenda, which are add-ons in North Carolina to the contract to supplement it, and all these other forms, okay? So when we want something specific drafted up for our clients and we don't have a standardized form for it, who do you think we go to get something special drafted up?
Probably our BIC.
The BIC's just a special broker.
Why not?
Attorney?
Lawyer.
An attorney. There you go. It's law, right? We got to hire an attorney. Now, I mean, we can go ask our BIC for advice and get their, recommendation on an attorney, but drafting a legal document would be an attorney that we'd have to hire for that. So if there's any language that's not covered and we want to add it, hire an attorney. Can you have your client write the language themselves? Sure. But folks, what are the odds that your client who has never been to law school writes verbiage that is legally adequate to be enforceable in a court of law? Probably not very good, right? So a few moments ago, Jacob asked a very great question, and I'm going to give you a very testable answer. In North Carolina, we do things a little different than other states on many fronts, okay? And it's not necessarily a bad thing. I would argue that it's a good thing, but that's a conversation for another day. But here's the deal. I keep referring to this standard 2T. And Jacob asked, is it the contract? No. It is just one that we use a lot. A lot. And so it is suitable for residential resale transactions, which the majority of sales are. Yes, there's a lot of new construction out there. This would not be adequate by itself for new construction. But residential resale properties, it would be completely adequate for. And so it is kind of the default one. It is the one that you will use most. I would say 80 to 90% of any contracts that you ever do in your career will probably be utilizing the standard form 2T. But it is extremely testable to understand that it is not the only form. So here's where I will introduce another rule. You see the number on here. It's 58A.0112. You do not need to know the numbers ever. But if you wanted to make a note and look it up in there, you could find it. So 58A.0112 deals with sales contracts. And so what it states is that a broker assisting a client can utilize any pre-printed sales contract drafted by an attorney, so long as it contains 19 required provisions, and so long as it does not contain 2 prohibited provisions. And so this contract was drafted in a way that it meets those requirements. It contains all the 19 items that are required to be in there. And it doesn't contain the 2 prohibited that aren't allowed to be in there. Well, let me show you this really quick. I'm going to bring the License Law and Commission Rule Book back up. When I say 58A.0112, that is a commission rule. So we're going to go down to page 50, which is where they start. Right here. Offers and sales contracts. What you got, Jacob?
So the NCT2 is that. So you said it's
2T.
the most common and it's basically standard. But like, is that the standard? If I get an NC question on my test, then it's talking about contracts. Should I assume that it is the T2?
2T. They will not have you assume anything like that on the test. But what they may ask, let me give you an example of what you may ask. Jacob is a broker assisting a first-time buyer who is interested in purchasing a resale, single-family detached home. Which of the following might be a legally adequate contract available for Jacob, who is a realtor in North Carolina, to utilize for this transaction? The standard offer to purchase in contract form 2T, because it is resale, it is residential, and you are a realtor. We're going to get into that in a second. These are branded for the use of realtors only. But they're never going to ask you to just say, somebody's buying a house. What's the standard form? That's too vague. We'd have to give you more detail, right? So here's how this starts. I'm not going to read all 19 provisions to you, but you'll kind of get the feel for what it's talking about. A broker acting as an agent in a real estate transaction shall not use a pre-printed offer or sales contract form unless the form describes or specifically requires the entry of the following information: names of the buyer and seller, legal description of the property, itemization of any personal property to be included in the transaction, purchase price, manner of payment, any portion of the purchase price paid by promissory note. I'm just going to skip around. Any loan that must be obtained, general statement of the buyer's intended use of the property, amount and purpose of special assessment. So it goes on, and there are 19 of them. So here's 18, jumps up to 19. Now 20 is kind of a generalization. It says any other provisions or disclosures required by statute or rule. So here's where the two prohibited things come in. And I promise they're testable as well on the North Carolina side. A broker acting as an agent in a real estate transaction shall not use a pre-printed offer or sales contract form containing 1. Any provision concerning the payment of a commission or compensation, including the forfeiture of earnest money to any broker or firm. So in other words, we can't talk about brokerage compensation on the sales contract because we're not a party to the sales contract. Where do we talk about our brokerage compensation?
In your contract you have with the
Listing agreement, right?
Agency contracts, right? Buyer agency agreement, listing agreement. That's exactly right. So then the other provision that's not allowed, any provision that attempts to disclaim the liability of a broker for his or her representations in connection with the transaction. So no disclaimer of liability. You cannot use a contract that has those two things on there. It's not allowed. Now that being said, it just so happens that the 2T checks all these boxes, and it is designed to be utilized for resale residential transactions. So it is very commonly utilized, but it is not the only form, period. There are lots of other ones. Just for an example, when you look at it, it's called the Offer to Purchasing Contract Standard Form 2T. Well, there's another one for new construction called the Offer to Purchase and Contract New Construction, which is 800T. There's another one called the Offer to Purchase and Contract Vacant Lot and Land, which I don't even remember the number for that one off the top of my head. But you see what I'm saying? There's different ones for different types of transactions. One for new construction, one for dirt. This one's for resale residential. Everybody still with me so far? Stephanie, you look like you have a question.
I don't have a question. I actually understand right now.
Okay. All right.
So I'm good.
Good deal.
I'm just trying to compartmentalize in my brain.
All right, listen, I get it. I get it.
Good question.
Yep.
So, when you said the 800T is for new construction, right?
Mm-hmm.
Majority of the time. So, for example, I have a buyer, I'm a buyer. I go in, it's my 800T, it's new construction. My loan falls down. So my sister goes in, she's now wants to buy this same house, whatever, new construction. Would it be under 2T or 800T at that point?
You were under contract on a new construction house, your deal fell through, and now your sister wanted to buy it?
Yeah.
It's still new construction. New construction means first occupancy. You never moved in. Yeah. Yeah.
But isn't 2T just for vacant, unimproved land?
No. The 2T is for improved single family. Well, actually, I keep saying single family detached. Improved resale residential. Resale residential. Now, remember, residential is 1 to 4 units. It could be fine for a resale townhome. It'd be fine for a resale duplex. Be fine for a triplex, quadruplex. It'd be fine for single family detached. Resale residential means 1 to 4 units, never been occupied before. Let me show you this.
Wait, you said resale but never been occupied before?
No, resale residential.
Okay. Okay. What was the never been occupied before?
New construction means never been occupied before. So it has to have been, if I said never been occupied, I mean it has to have been occupied before. It is for resale residential, meaning it has been occupied before, so we're selling it again. It is a resale. That's what resale means. New construction is never been occupied before.
And
Yep.
that is simply just 2T. There's not a 12T or anything in that?
That's a different form.
Okay.
Let me show you this real quick. This will help. So if you look, this is a list, and you have this entire list in your online curriculum down towards the bottom. It's called NCAR forms. Folks, NCAR stands for North Carolina Association of Realtors. So every single form we're talking about, remember when we differentiated between broker, agent, and realtor. These are all for realtor use only. You have to be a realtor to use these forms because they are not drafted by the Real Estate Commission. They are drafted by the Association of Realtors in conjunction with the North Carolina Bar Association, attorneys. But look at the numbers here. 2A1-T, 2A3-T, 2A5-T, 2A13-T, 2A12-T. There is a crap ton of forms. Most of these are not testable. So you've probably seen these before if you scrolled through some stuff. I'm going to focus on the testable ones. What we're talking about right now is this one, the 2T. Offer to purchase in contract, and if you look right here, standard form 2T.
And that's for resale residential.
Yep. Resale residential. So we're going to come back to this in just a second after I hit on a couple other things. Oops, went too far here. Oops, no. There we go. So let me show you this. So we just showed you the rule, the 19 required things, the 2 prohibited things, but here's what I'm telling you. These are all branded for realtor use only. Let me just bring it back real quick and show you, because I didn't show you that yet. Right here is the realtor logo. That says you can't use this unless you are a realtor. This form jointly approved by NC Bar Association in conjunction with NC Realtors. So it is important to know that the North Carolina Real Estate Commission, who is the person, the authority that you're getting your license from, does not author any of our standardized forms. There are 3 forms that you will utilize day in and day out that we've already talked about that are authored by the Real Estate Commission. Who remembers what they think they are?
WWRE, the
Working with Real Estate Agents Disclosure.
residential, that's a disclosure,
The RPODS, Residential Property and Owners Association Disclosure Statement.
the minerals and
Mineral Oil and Gas Rights Disclosure, the MOG. That's exactly right. There you go. Those are all authored by the Real Estate Commission, but not the standardized forms that we're about to talk about. Those are NC Realtors, okay? Jacob, the other thing that was prohibited, no discussion of brokerage compensation, no disclaimer of liability. Saying, don't come at me, bro, if I screw up. You can't put that in there. There you go. So the North Carolina Real Estate Commission, it's kind of ironic that we even test you on these forms considering they're not authored by the Real Estate Commission, but the Real Estate Commission is the one that writes the test. Yeah, I don't know, Kirsten. We've all asked that for years. Why is this on the test when they don't even author them? But of course, you know, it just is what it is. I mean, they're very important. This is like the one section that you will absolutely use in your career. So this is like the most useful, hands down, to have a basic understanding of as you get your license, but it's never been extremely testable, and they don't offer the forms, which makes it weird for them to write the test, but whatever. I don't know. So we already talked about this, folks. Can never have disclaimer of liability, and they cannot put in anything that talks about brokerage compensation. Now, this last little note is just clarifying, does address the seller's remedy for breach of contract by the buyer. Now, that is outlined in some of those provisions that are required. What happens if... You'll find that if you actually look at the offer to purchase and contract standard form 2T from start to finish, it is exceptionally thorough. Is it perfect? No. But it is exceptionally thorough. Now, folks, it is, listen to me, 17 pages for one document. As much as there might be new questions on it, I'm going to teach you the most testable pieces. You're welcome to go back and peruse it, but I'm going to tell you what I know is going to be on the test. Outside of that, you know, you may have some crazy little tidbit stuff, but the reality is all the questions are going to be probably pretty similar based on the major testable things that I'm going to talk about, okay? So this I already told you as well. Parties to the contract can alter, amend, they can draft their own contracts. If you're doing it for somebody else, that'd be the unauthorized practice of law. If there's anything we need to add in, we need to have an attorney do it. Of course, we as real estate brokers, right now I'm just making general statements. We as real estate brokers can change our agency contracts because we're a party to it, but we can't add any special language to the 2T because we're not a party to it. Remember I told you like really early on in class, you've always got to be thinking about who are the parties to an agreement, because that changes the entirety of the question. I've already told you this. I'm not going to give you that one. So let me show you the actual form, and let's just start talking about it, okay? Because it's going to be the easiest to just do it that way. So I want you to think about when we were talking in basic contract law section. And I said, okay, well, every contract is voluntary. And every contract starts as a what?
Agreement.
A date of
An offer.
An offer. Every contract starts as an offer. I want to buy your house for $2 million. That's an offer. And so that is why this is called the offer to purchase and contract. It starts as an offer, but if all parties agree, can become a contract. Remember, these are very different things. Offers are very easy to kill. Contracts are not. If you break a contract, you are typically subject to penalties. Offers, not so much. Remember the other thing I told you too. One of the big differentiations is that death of a party would kill an offer. But death of a party would not kill a sales contract. So if this is evolved into contracts, into a contract, then death of the parties, it would survive death, okay? Now, this is just talking about some basic verbiage. For valuable consideration, the receipt and legal sufficiency of which are hereby acknowledged. Buyer offers to purchase, and seller upon acceptance agrees to sell and convey the property on the terms and conditions of this offer to purchase and contract, and any addendum or modification made in accordance with its terms, together referred to as the contract. So here's where we would outline the seller and the buyer. Now, folks, I don't know how testable it is in pre-licensing, but I'm going to give it to you anyway. It is very important to understand that we need legal names, okay? No nicknames, and we need titles is the legally adequate way to put this in. So if your sellers were a married couple going by the name Jane and John Doe, you would not just put John and wife, Jane. You would not put John Doe and wife. You would not, it would be John, middle initial Doe, and wife, Jane, middle initial Doe. That is the best way to do it. Why? Because John and Jane could be brother and sister. So we need their actual legal names. We need to know their titles. Are they siblings? Are they spouses? What is their status? I don't know how testable that is, but just in case. So this is where the legal description comes into play. We talked about legal descriptions already. It's not enough to just say 123 Main Street. So we name the informal reference, which is the street, but then we've got reference to recorded plat, that lot and block method. Then we've got some tax IDs. We got reference to a recorded deed. The reason is we want to make sure that everybody knows which property is actually being conveyed. And yes, this is the 2T that we're looking at right now. Here's where we start getting into some terms. How much are you offering? You put in purchase price. You put in the due diligence fee, if any. You put in earnest money, if any. Additional earnest money. Seller financing, assumption, building deposit, balance. Now, folks, I'm breezing over this because filling out one is not going to be part of your test. We talk about that in post-licensing. I'm just hitting the key points here. Now, I am going to go back up here because something tells me this is testable. I'm going to explain due diligence and earnest money in just a moment. But you do need to know that due diligence fee is due on the effective date. Folks, what is the effective date, do you think?
The date that you signed the contract.
It's not enough.
The date that both parties signed the contract?
One more piece.
And it's delivered.
Delivered, what's the better word?
Accepted.
Communicated.
Communicated. Communicated. They don't actually have to see the contract. You just have to tell them that you accepted it. So remember, we don't have a contract until you have signed it with no changes and communicated that acceptance to the offeror or the offeror's agent. So the effective date is the day that it was signed by the offeree and communicated back to the offeror or the offeror's agent. The date, the second, right? The day that it turns into a contract, right? It evolves from that offer, becomes a contract. Everybody okay with that? Very testable. Due diligence is due on the effective date. In regard to the offer to purchase and contract standard form 2T. Folks, you will not see the term due diligence on the national exam. You won't, I promise. Or if you do, it'll just be the way that you've used it up until now, right? Doing your due diligence, right? Just looking into it. That'll be the generalized terminology if you ever see it on the national, but I'm pretty sure you won't see it just because of the, contradictory nature of it. So due diligence is a very specific thing in North Carolina on this 2T. We're going to get into that. Now, we talked about earnest money. Earnest money is, what do we call it from a remedy point of view? What was the other name for it?
Isn't earnest money and due diligence the same thing?
No, absolutely not.
Liquidated.
Liquidated damages. There you go. So due diligence fee, notice the words too. Due diligence fee, earnest money, deposit. Very different things. A fee and a deposit. A fee and a deposit. I'm going to provide some more insight here in just a second. Hang tight, Jacob. I'll make it all make sense, I promise. So notice when it is due. Earnest money is due within 5 days of the effective date. Okay? Earnest money is due within 5 days of the effective date. Now here's the big difference. Due diligence fee at the time of the contract is paid to the seller. The earnest money deposit is paid into an escrow account where some third party is holding on to it in case the buyer breaches. So it's earnest money sitting in an escrow account. If you mess up, this is liquidated damages the seller is entitled to, Mr. and Mrs. Buyer.
So the only difference is that...
Don't guess, just wait. Don't guess, just wait. You're going to confuse yourself more. Hang tight. There's a huge difference. Hang tight. Now, this right here is what we call additional earnest money. It is something you could negotiate where you basically put more money into that trust account or escrow account. Remember, trust accounts are where we hold money belonging to others. They are custodial. They are not being utilized. It's safeguarding money for a certain time or trigger to happen. We'll talk more about those down the road, but trust account, escrow account is being safeguarded by a third party who's unbiased. So I'm going to circle back around to this provision here, but I want you to understand due diligence and earnest money first, okay? So because earnest money appears first on here, I'm going to explain earnest money first. Earnest money deposit, the initial earnest money deposit, the additional earnest money deposit, and any other earnest monies paid or required to be paid in connection with this transaction, collectively referred to as earnest money deposit, shall be deposited promptly and held in escrow by escrow agent. The earnest money deposit will be credited to the buyer at closing or dispersed as required by this contract. Now, folks, we've talked about credits and debits. So, yes, this earnest money goes into an account. Let's say it's $5,000. And it's sitting there as liquidated damages. It says if the buyer screws up, the seller is entitled to it as liquidated damages. But if the buyer doesn't screw up, they're going to get it applied towards their closing cost. So it would be taken from the escrow agent who's holding it, and it would be what we call a single entry credit to the buyer. We've been holding this $5,000 for you. Here, have it back. Everybody okay with that statement? It would only serve as liquidated damages if they screw up. But if they don't screw up, they get it back. So here's where we name who's going to be holding it, called the escrow agent. Buyer and seller consent to disclosure by escrow agent of any material facts pertaining to the earnest money deposit to the parties to this transaction, the real estate agents, and the buyer's lender. So if the check bounces, if the check's invalidated, if something happens, they would have to disclose information. So it's who's going to hold it. Now, this is something that's extremely testable, folks, okay? I told you that the earnest money is due to the seller if and only if the buyer does what? Breaches. Breaches. So if they terminate during their due diligence period, that's not a breach. We're going to talk more about that in a second. So the only way a buyer can breach is if they don't buy the house or do something after the due diligence period has ended. Well, here's something that you have to understand. This contract is incredibly thorough in regard to who is entitled to it when. However, we as real estate agents, acting as an escrow agent, because it could be us, it could be an attorney holding this money, we cannot make decisions, even though we know who the money is supposed to go to. So let me show you what I mean. Folks, let's say it's the day before closing. We're past our due diligence period, and the buyer loses their job and doesn't buy the house. That buyer is in what? Breach. So who should get the earnest money deposit if there is one? The seller. Here's the key takeaway. We can't give it to the seller if there's what we call a dispute. We know the seller is entitled to it, but if the buyer was to say, don't you dare give him my money, we cannot disperse it to them. We have to have a release from both parties consenting to us dispersing it, even though we know who it's supposed to go to. I promise you this is extremely testable. So look right here. In the event of a dispute between seller and buyer over the disposition of the earnest money deposit held in escrow, a licensed real estate broker is required by state law, and an escrow agent, if not a broker, hereby agrees, meaning an attorney holding it agrees, to retain the earnest money deposit in the escrow agent's trust or escrow account until escrow agent has obtained a written release from the parties consenting to its disposition, or until disbursement is ordered by a court of competent jurisdiction. Alternatively, if a broker or an attorney licensed to practice law in North Carolina is holding the earnest money, the broker or attorney may deposit the disputed monies with the appropriate clerk of court in accordance with the provisions of North Carolina General Statute 93A-12. So even though we know who's supposed to get it, we can't give it to that person if they're not in agreement. So the buyer would basically have to sign a written release saying, yes, I know, give it to the seller. And if they don't, then we would continue to hold it, or we could turn around and deposit it with the clerk of court and say, y'all go to the clerk of court to fight for it. Those are our options. Very testable.
So, Seth, the escrow agent will always be either a broker or an attorney?
Yeah, basically. For all intents and purposes, just think of it that way.
Okay.
Can the escrow agent be a broker that's working, like that represents the buyer or seller?
Absolutely. Because they've agreed to hold it as a non-biased third party. Is there some bias? Of course, but they have to follow these rules, so it doesn't really matter. So not uncommon for like the listing agent to hold it on behalf of their seller. It's not uncommon for the buyer's firm to hold it. Just depends on what we agree to. So we talked about the effective date, and you told me, but here's where I will revisit it and make sure that you understand, because we've already talked about the effective date, but here it clearly states it. I told you, this thing is thorough. The effective date is the date that the last one of the buyer and seller has signed or initialed this offer or final counteroffer of any, and, right, big emphasis on that word and such signing or initialing is communicated to the party making the offer or counteroffer as the case may be. It's not enough to just be signed. Signed and communicated to the offeror or the offeror's agent. That's the effective date. So the due diligence is due that day. The earnest money is due within 5 days of that day.
One question, business days or 5 days in?
Calendar for this.
Okay.
Calendar, absolutely. What you'll see in a little bit when it talks about computation of days, it says calendar unless otherwise stated. And since it just says days, calendar. Yep. Now, I don't think this is going to be testable, but what it basically goes on to say, when it's talking about initials, it's talking about initialing like a counteroffer where somebody put the strike through. But it goes on to say that the initials at the bottom of these pages are a formality, that this would not constitute a, basically you still have a contract even if you don't initial these pages. That's all it says. It just says, the complete execution of such initial line shall not be a condition of the effectiveness of this agreement. As long as you signed it and communicated, you're under contract, even if you didn't initial these little lines down here. But you do need to initial any strike-throughs in regard to a counteroffer. Now, here's where we get into the other doozy, okay? And so here's where things change a lot. We've talked about earnest money a little bit. Now we're going to talk about the due diligence fee, and then I'm going to make sure that you have a couple of examples to hold on to in your brain. So the due diligence, as they're calling it here, is sometimes called the due diligence period. Buyer's opportunity to investigate the property and the transaction contemplated by this contract, including but not necessarily limited to matters described in paragraph 4 below, to decide whether the buyer, in the buyer's sole discretion, will proceed with or terminate the transaction. That's why it's unilateral. That due diligence is the period of time to decide, do I want to buy it or not? They've never promised to buy it. Said, give me this period of time to decide. That's due diligence, which is exactly like an option to purchase. Here's the tie-in. We talked about unilateral, but you didn't understand this enough yet, and I said I was going to wait to make the tie-in. Due diligence periods, unilateral. Option to purchase, unilateral. Both have periods of time for you to decide. Both have monies typically accompanied either due diligence fees or option fees. And then, of course, if you exercise your option or you move past your due diligence period, now it's bilateral, which is the reason why a buyer can't breach until after the due diligence period, because they have purchased the right to terminate during due diligence. What you got, Misty?
So they purchased the right. That means they don't get their due diligence back if they decide to terminate?
Correct. Due diligence is non-refundable. They bought that right. That's why the difference exists. That's why we call it a due diligence fee versus an earnest money deposit. Deposits are slated to come back to you as long as you don't do anything wrong. Fees, you purchased that right to have the ability to walk away.
That's very different from back in the day.
Very different.
Yeah, very different.
So with that, due diligence, does that get credited back to you at closing, or?
Yes.
No?
Yes, absolutely. So if you walk away, that's all you've lost. But as long as you go to closing, you're going to see that we're about to read that in this fee. It does come back to you. Now, folks, everybody wants to talk about this, so let me just talk about it because I'm about to send you on break anyway, and then we'll read this, okay? Let's say that you got under contract on a house, and you offered $1,000 in due diligence and $10,000 in earnest money. You had a 3-week due diligence period. On week 2, you had a home inspection. The foundation is crumbling. You can walk away for any reason or no reason. That's very important. Any reason or no reason. In this case, you just happen to be walking because of the foundation issues. You lose your $1,000 in due diligence, even though there's problems with the house. But you get your earnest money back because you terminated during due diligence. Folks, look at the big picture. It's well worth losing $1,000 over being on the hook for the $80,000 in foundation issues. That's how this contract is written. You have purchased the right to walk away. If you walk away, you lose that money. But if you don't walk, it does come back to you. It's still your money. You look like you're going to say something else, Misty. Yeah.
So how is due diligence in the best interest of the buyer? It seems like a offer contingent on a home inspection would be more protective than having to be out of pocket money for due diligence.
Yes, but I will tell you due diligence wasn't, it was, well, how about this? I'll let you take a break first, and then I'll explain why it exists for both the buyer and the seller. I'll give you a little bit of a history lesson and tell you that. So y'all go take a break, come back at, I'll give you a couple extra minutes, 7:27, super random time, 7:27, and then I'll give you a little backstory here. So we are currently discussing the offer to purchasing contract, standard Form 2T. Not the only contract utilized in North Carolina, but a very commonly utilized contract for resale residential properties, okay? Utilized by realtor members only, and we're talking about some of the most testable provisions within here. And so we're discussing earnest money, now we're getting into due diligence, and I just told you that due diligence periods are a period of time for buyers to investigate the property and terminate for any reason or no reason. And they are typically accompanied by a fee. Now, Misty is, been a broker before, back in the day, before Jacob was born, okay? And of course, things were done a little bit differently. Due diligence periods are relatively newer concept within the past 15 years, I would say. And so Misty's question before we went on break, well, why wouldn't we do that? Like, that doesn't seem like it protects the buyer at all. It actually wasn't designed to protect the buyer, although it inadvertently does. What would happen, the way that the contracts used to exist, is there was earnest money only, and then they would basically allow buyers to get under contract on a property and walk away without any penalties. So what buyers started doing is getting under contract on 6 different homes, figuring out which one they liked the most and had the least issues, getting under, or like actually moving forward with buying that one, and then they would terminate the other 5. And so all 6 of these sellers took their houses off the market for this one buyer, with only the buyer intending to buy one. So it was actually designed to protect sellers initially, to have the buyers have some skin in the game. So if you actually wanted this house, you had to have some buy-in that showed us you were serious in moving forward with it. Now, it inadvertently does protect the buyers because, as we talked about earlier, North Carolina is a doctrine of caveat emptor state. So it's protecting the sellers from the buyers wasting their time, but it also protects the buyers because the buyers could negotiate very small amounts of money if the seller is willing to take it to have home inspections and then terminate before they've got a lot of money on the line. So if you've got a house that's very questionable, you're not sure you're going to want to buy it, negotiate small amount of money. See if the seller will take $250, you know? Nobody should be crippled. If you're able to buy a house, $250 shouldn't cripple you. So there's no set price that it has to be. It doesn't have to be $50,000. It doesn't have to be $10,000. Now, you will never be tested on what the norm is. There's no such thing as the norm. For the longest time, though, just to give you some insight, because I'm sure you're curious, it was around 1% of the purchase price total between due diligence and earnest money. $300,000 house would typically have somewhere around $3,000 tied up into it between due diligence and earnest money. There you go.
So Seth, under I, due diligence fees, it says a negotiated amount, if any. So it doesn't have, you don't have to do that. Is that correct?
Correct. So that will lead me into another very testable concept, folks. I told you that contracts have to have consideration. So do not get confused and think that earnest money and due diligence are consideration. They are negotiating instruments. The purchase price is the consideration. So you do not have to negotiate any due diligence or any earnest money. If you offered 0 and the seller was inclined to accept it, you still very much have a contract. Everybody okay with that statement? So this next part goes into a little more detail in regard to the fee. And I told you, think earnest money deposit, it's a deposit held in escrow, and due diligence fee. I told you the big difference, aside from what I've already explained to you, the fee goes directly to the seller. The day that you get under contract, you cut this check, if you've negotiated it, directly to the seller. Earnest money goes into an escrow account. So here's what it says. Due diligence fee, a negotiated amount, if any, paid by the buyer to the seller with this contract for the buyer's right to terminate the contract for any reason or no reason during the due diligence period. That's very important, because I promise you what they'll test you on too is saying something like, well, the buyers negotiated $30,000 worth of repairs from the seller during their due diligence period. Can the buyer still terminate? Yes, they always can. Folks, if they wake up one morning and decide that their, great-great-grandmother came and spoke to them in their sleep and said, I shouldn't buy the house. My great-great-mammy said not to buy this house, I'm backing out. They can. It doesn't have to make sense. There's no rhyme or reason. They can back out for any reason, no reason, doesn't matter. Nobody can stop them because they have purchased that right in due diligence, okay?
But then they lose the due diligence.
They still lose the due diligence. There are only 4, and I'm going to name them just in case they test you on them, but there are 4 times that the buyer could get their due diligence money back. But under typical circumstances, if they terminate during due diligence, they've lost it. So it goes on to say, it's due to the seller on the effective date. It shall be the property of the seller upon the effective date and shall be a credit to the buyer at closing. So yet again, as long as you move forward with it, it comes back to you. So I told you when we're dealing with credits and debits, you have to think about, is it a single entry or a double entry? And is it a credit or a debit? Well, folks, on the day of the contract, it's money given to the seller. So let's say it's $1,000. Here's what happens. You're going to submit an offer. The seller accepts it. As soon as they accept it, you need to give them that due diligence check made payable to the seller. They are going to put it in their bank account. That check is going to clear. So that $1,000 is their property that day. Now, folks, being that it's their property, if they want to go out and buy $1,000 worth of tacos, they can. $1,000 worth of bubble gum, they can. $1,000 of crystal meth, they can. Okay? Ain't nobody stopping them from spending that money. But here's the thing. If the buyer moves forward, they have to give that money back to the buyer. So think of it as basically a cash advance on your proceeds. If when you sell your house, you were going to make $100,000. Well, you've already got $1,000 of it. If this buyer goes to closing, now you're only getting a check for $99,000. So while it is yours to spend, you're going to have to credit it back to the buyer at closing. So due diligence on the day of the offer, the day of the contract, is a check cut directly to the seller. But on the day of closing, when everybody's settling up, the seller has to reimburse the buyer. So due diligence is a buyer credit, seller debit. And earnest money is a single entry buyer credit. Because the attorney or firm, whoever's holding the earnest money, says, you didn't screw up, here's your money, you get it back. Does that make sense?
So it's that due diligence money never goes to the escrow account.
Never. It goes directly to the seller, always.
Okay.
Yep. So then it goes on to say, the due diligence fee shall be non-refundable, except in the event of a material breach of this contract by the seller. So in other words, if the seller breaches, that's part of that compensatory damages, right? Make me whole, reimburse me the money that you took from me. So we talked about breaching. When you breach, the other party can back out and get their money back. So we're going to talk about the remedies in just a second. Or if this contract is terminated under paragraph 23B, which deals with remedies, we'll talk about that, or is otherwise provided in any addendum here too. Now, this goes on. I'll read it, but it's not as consequential. Buyer and seller each expressly waive any right that they may have to deny the right to conduct due diligence or to assert any defense as to the enforceability of this contract based on the absence or alleged insufficiency of any due diligence fee, it being the intent of the parties to create a legally binding contract for the purchase and sale of the property without regard to the existence or amount of the due diligence fee. So in other words, if it's $0, we still have a contract. If it's $1, we still have a contract. Okay? We very much have a contract even if there's no due diligence, even if it's small due diligence. We still have a contract if there's no earnest money or little earnest money, because there is still consideration, which is the purchase price. Everybody good with that statement? So here's something you have to understand. I keep referring to a due diligence period. It is a timing thing. There is a period of time. The period starts on the effective date, the day that we have a contract. And it moves to whatever we negotiate. So here's where we negotiate it. The period beginning on the effective date and extending through 5 p.m. on whatever date. Now, folks, we talked about this last week. Time is of the essence, or time being of the essence. That means there is no wiggle room. So here's what that means. If you are a buyer, and let's say that we put in here, today, tomorrow's date, okay? Let's say we put March 5th of 24. It's tomorrow. Well, if you were a buyer under contract, and that was the date, and you terminated the contract at 4:59 p.m., you get your earnest money back. If you were a buyer under contract and you terminate at 5:01 p.m., that earnest money is due to the seller as liquidated damages. Those minutes make a difference on whether or not you're breaching the contract. Time is of the essence. The date is the date is the date. The time is the time is the time. If you are past 5 o'clock, you are outside of your due diligence period. No ifs, ands, buts, or coconuts. Before you ask it, it's North Carolina time. You like that, right, Stephanie? I knew the question. Somebody was going to ask it, so I had to say it. You know, well, I had to say it.
You're being a mind reader.
Uh-huh. So,
But there's no set in stone, like, I know, I guess realistically, like a month for due diligence, but there's no, I mean, they could put whatever date they wanted on the line, basically, as long as it's a mutual agreement between the two parties.
that's exactly right. Folks, everybody wants to know the standards, okay? And just like I told you, due diligence, you will never be tested on a standard amount for due diligence. There isn't one. But yes, in industry speaking, for a long period of time, it was 1%. Now, there's no standard, but industry speaking, the general time frame that we like in a normal market, 3 weeks, 21 days, because that gives us enough time to have inspections, re-inspections, evaluations, and terminate in a timely manner. But if we agreed to a 6-month due diligence period, we could. If we agreed to a 1-day due diligence period, we could. But the reason you have to understand that this date's very important, right? Because it's times of the essence. And what you agree to is what you agree to. So let's say that you agreed to a 7-day due diligence period. On day 7, your inspector canceled on you. You don't know anything. If you go past your due diligence period by 1 minute, your earnest money is now live. If you terminate after, you would lose both. Is this making sense for everybody, this differentiation between due diligence and earnest money?
Yeah.
So I'm going to touch on the other very testable pieces, and then we're going to move on because, like I said, even with the addition of more questions, they're not going to get too specific. You know how I know that? Folks, the entirety of Post-Licensing 302 is to go over this contract line by line. So they're obviously not expecting you to know this contract line by line as a pre-licensing student, because if they did, what the hell would be the point of Post-Licensing 302? Just a theory, but it's a pretty good one. So as this goes on, settlement, remember, settlement is the meeting. So settlement, the proper execution and delivery to the closing attorney of all documents necessary to complete the transaction contemplated by this contract. So this is where all parties go to sign. And it's an attorney handling it in North Carolina. In other states, we said this settlement meeting could be handled by title companies. So the settlement date is a negotiation point. When are we all intending to go to settlement and or close on the property. Closing, for the sake of this discussion, is defined as recordation of the deed. Just think about it that way. You are not considered to be the owner in North Carolina, even though we talked about deeds being valid without being recorded. I told you in North Carolina, we do not consider you to be the owner until we record the deed in your name. So that is closing. What you got, Sam?
I'm kind of curious. It sounds like attorneys are involved with this contract. How do they get compensated?
They get paid by the buyer at closing. Actually, they technically get paid by both. We're going to talk about that a little bit later, but they do a title search for the buyer. They technically work for the buyer. They would, deal with all the loan paperwork. And so they charge the buyer. That's part of your closing costs. When we talk about closing costs, attorneys make anywhere from $1,000 to $1,500 on behalf of representing a buyer at closing. And then for a seller, they do what's called deed preparation. They are preparing the deed to transfer to the new buyer. And that's anywhere from $200 to $500. So that's how they get paid. So an attorney makes on average about $2,000 per closing. And they do way more closings than we do a year. So closing, just a quick little rundown of steps. Settlement, which is the meeting as defined above. The completion of a satisfactory title update. The closing attorney's receipt of authorization to disperse the funds, and recordation in the appropriate county register of deeds and deeds of trust, if any. So recording the new deed and deed of trust. We talked a little bit about deeds of trust and specific liens, but of course we will talk more in financing very shortly. Special assessments we talked about. When did we talk about special assessments? What did I tell you about them early on in this course? If you're reading this, it won't help you.
It
You
was
have to pay for it.
improvements that the government make and the
Yeah, it is when a taxing authority or some kind of governmental authority or sometimes an HOA does something to make your property more valuable and they charge you a bill for it. It's called a special assessment. But what did I tell you about them? Say it again?
Which about like putting in sewer pipes.
Yeah, that was an example.
But the tax is only for a periodic period. It's not an indefinite tax.
Well,
Is it an appurtenance or the word where it runs?
an appurtenance, yeah. Here's the other thing that I will remind you that I told you. Remember when we talked about specific liens a little bit, those are liens that attach to a specific real property. So it is a specific lien that attaches to your real property. And so it was a special priority lien. Most states, including North Carolina, is a pure race state. First come, first served. You recorded first, you would make the money first if there was a foreclosure. But remember, real property taxes are a higher priority that beat out everything. Special assessments beat out everything except for real property taxes. So remember we talked about it being a special priority lien. They would have to be paid out before any other liens that were recorded, second only to real property taxes. That ring a little bit of a bell? There you go. Now this section we looked at already as well. Earlier on we talked about fixtures being part of the real property versus personal property. We also looked at the listing agreement and I told you this is mirrored. What this basically says is that everything on this list is a fixture that will be included in the property if it exists in the property and transferred at no cost to the buyer. And so there's a very detailed list. Remember I told you if we are dealing with fixtures on a contract, when is the only time that we would need to specifically name a fixture on a sales contract?
If it's going to leave with the seller.
If it's going to do the opposite of what it's intended to do. A fixture is intended to stay for the new buyer. So the only time we would need to mention it is if it was intending to leave with the seller. And so when is the only time we would need to talk about personal property on the sales contract?
If it's going to stay in
If
the
it's
house
going
with
to,
the buyer.
there you go. If it's going to do the opposite of what it's intended to do. Personal property is supposed to leave when the seller moves out. But if we wanted them to leave it for our buyer, we would need to name it. So here's a detailed list of things that we say are going to stay in North Carolina. And if we wanted to exclude anything, you would name it as an exclusion here. Yes, it's a fixture, but we're taking it with us. If all parties agree, that's fine. Yes, it's personal property, but we want to leave it for us or for the buyer. If all parties agree, it's fine. Now, one other quick mention from a way back when is this leased thing. What comes into play here, if a property or something is leased and not owned, this could include the or bring in the UCC, Uniform Commercial Code in North Carolina, that says even though something may normally be considered a fixture, it will remain personal property if a debtor or a creditor has the right to, go after it because you still owe them money. And I gave you the example of like, a dishwasher from Rent-A-Center or something like that. What you got, Monica?
That's a mechanic's lien, right?
No, well, so a mechanic's lien could be put on the property for something like an HVAC system installation, but the Uniform Commercial Code is basically just a security agreement recorded against something because you haven't paid it off yet. So you could have a Uniform Commercial Code could come into play for both like an HVAC unit that you have, payment installment plans on. But then they also, for the labor, could record a mechanic's lien saying until you paid it off in full, we have the right to go after your property for it. So slight differentiation, but very similar concepts it could be. Yeah. Due diligence period. Folks, let me tell you the other really important thing to understand, okay? What is a contingency?
A contingency is something that you put in a contract, and it's basically it's like saying that you'll buy the house as long as it appraises or whatever, and if that's not the case, then it's way out with all of your money.
There you go.
It stands in the way. It needs to be met in order for there to be contract.
There you go. And now we can have a contract, but basically, it could, that's right. It could allow you to get out of the contract, right? It's that get out of jail free card, as y'all just told me, right? So if we put in some type of financing contingency, hey, if I can't get financing, I'm get backing out and I don't want any penalties. If I can't sell my house, I'm backing out. I don't want any penalties. Those are just some common examples of a contingency. Now, folks, look right here. There is no automatic contingency in any contract, and this one included. There is no loan or appraisal contingency in this offer to purchase and contract. Now, let me tell you something here. When you answer a question on the test, do not ever use your emotions, because if you do, you will get the question wrong. Let me explain why. If we have a question that says, a buyer is under contract using the standard offer to purchase and contract Form 2T in North Carolina and has $50,000 in due diligence money on the line. The day before closing, they lose their job and they can't close. What is going to happen to the due diligence money and the earnest money? They will lose every penny, folks. There is no contingency built into this contract. And this is why I'm saying you can't answer with emotions. Oh, my heart bleeds. This person's going to lose $80,000 because they lost their job. That doesn't sound right. That can't be the answer. I'm sure they'll get it all back. Wrong. Do not answer the questions with emotions. Don't put yourself in the shoes of these fictitious people that don't exist. Okay? Let Jane Doe and John Doe get screwed over and just focus on being the best broker you can be so this never happens to people in real life. But do not ever answer your questions emotionally. I don't like this. If it was me, I wouldn't do that, so this must not be true. Don't answer them that way. Let me remind you when we talked about agency contracts, same thing. Seller wants to get out of their agency agreement with their, agent because they don't like him anymore. Oh, they should be able to get out because they don't like their agent. That seems fair. Nope. Don't answer that way. Sucks to suck, Chuck. A contract is a contract is a contract. Never answer questions with emotions. There is no contingency in any way, shape, and form in this contract, this 2T. Everybody good with that statement? Could you hire an attorney to add one in by way of an addenda? Sure. But that's not the majority. That is not the default. So if you get a question on, is that possible? Sure. Everybody good with that statement? Now, this next little section is just talking about things that you might consider doing during due diligence. Having inspections on the home. Very good idea in North Carolina. Doctrine of caveat emptor state. Home inspection. Make sure there's no major issues. No mechanical, no leaking, no foundation, no standing water, no drainage problems. So we want to have those checked out. May want to check for environmental issues like radon, lead. Well tests, septic tests. Okay, a lot of tests that come into play. Checking your zoning, your restrictive covenants, making sure the allowable uses exist, making sure you have utilities, making sure you can get insurance on the property, Making sure that your appraisal comes back good. We'll talk more about appraisal soon. Making sure that it's not subject to any flood hazards. Making sure that the streets, figuring out if they're public or private. A lot of different things that we would use that time to evaluate as a buyer in North Carolina. This is an important piece, okay? Understand that this contract clearly states that the house is being sold in its then current condition. Means good, bad, the ugly. You are buying it the way that it is set. However, it does go on to say that you could negotiate but are not required to repairs or things of that nature. So repair/improvement negotiations agreement. Buyer acknowledges and understands the following. Unless the parties agree otherwise, in all caps, the property is being sold in its current condition. Seller may, but is not required to, engage in negotiations for repairs/improvements to the property. Buyer is advised to make any repair/improvement request in sufficient time to allow negotiations to be concluded prior to the expiration of the due diligence period. Why? Why do we want these negotiations to happen before the end of the due diligence period?
So they have because if they're not fixed, then why would you follow through with buying?
They're not fixed. Why? Sometimes you would, depending on maybe it was just something trivial you asked for.
Because if it's something major, you can still back out. You still have time as long as it's before 5 p.m. on the date agreed in the contract.
There you go. You minimize your loss. If they tell you to go fly a kite and you've come to that conclusion before the end of your due diligence period, you can minimize your loss, you can terminate, and all you've lost is due diligence. If these negotiations happen after the due diligence period, you're screwed, especially if you got a sizable earnest money on the line. Because now if you leave, you are in breach, and they would get to keep your earnest money as well. You lose your leverage. Think about it. If you got $1,000 in due diligence money and $10,000 in earnest money and you're asking for $2,000 worth of repairs, they may think that you might walk over an extra $1,000 and only losing one. If you're past your due diligence period and you are at risk of losing $11,000, there's no way you're walking over $2,000 worth of repairs. You've lost your leverage, you've risked your money. Buyer's right to terminate any reason or no reason. Closing constitutes acceptance. If you close on the property, you have accepted it in its then current condition. Funds. This is part of those requirements under the provisions of 58A.0112. How are you paying? Is it cash? Are you getting a loan? What type of loan? Folks, let me make a statement here. The seller has every right to know where your money is coming from, so they can make an adequate decision on whether or not it's an offer they want to take. No, it is not discriminatory to turn down a certain loan type. There is no such thing as source of funding discrimination. So they can turn down VA loans, they can turn down USDA loans, they can turn down FHA loans. No, they have not violated any fair housing laws or anything like that. Understand that this little section right here, if you read through it, it's just asking if you have another property to sell in order to qualify for a loan, but it's not creating a contingency. It's factual only. Tell us if you have another property to sell, but regardless if you terminate or not, you're still bound by the due diligence and earnest money criteria. So this is not a contingency. Do not read this and think that it is. Do you have another house to sell? Yes or no? Tell us about it, but it is not. Contract is not conditioned upon the sale or lease of another property. If you can't sell your house, you still have to give us your due diligence and earnest money. You're penalized. Now, here's where I can tie back into an earlier concept. Remember when we talked about the ARPODs and the MOG? I'm going to scroll up here. Folks, tell me who fills out the ARPODs and the MOG when required. Seller. And who do they need to go to?
The buyer.
The buyer. When?
During due diligence?
Before the
So
offer
it's
is
an
made.
agreement, right?
Prior to making an offer. They have to be given to the buyer prior to making the offer when they are required to be in compliance with the Residential Property Disclosure Act. Now, what happens, do you remember, if you have not given them to a buyer prior to them making an offer.
They can rescind their offer within 3 days? No?
Yeah,
Yeah?
yeah,
No?
yeah, yeah, right. Yeah, folks, here's where we can bring this full circle. Residential Property and Owners Association disclosure statement. There are 3 check boxes on this contract. Your check boxes are, I have gotten it, I've not gotten it, or it's exempt. If we have gotten it before making this offer, then we are in compliance with the Residential Property Disclosure Act as long as we received both the MOG and the RPODs when required. However, if either of the MOG or the RPODs are checked, here's what it says. Buyer has not received a signed copy of the RPODs prior to making an offer and shall have the right to terminate or withdraw this contract without penalty, including a refund of any due diligence fee, prior to whichever of the following events occurs first: the end of the 3rd calendar day following receipt of the disclosure statement, the end of the 3rd calendar day following the effective date, or upon settlement or occupancy. So I told you there are very specific circumstances where you could get your due diligence back. This is one of them. If you get under contract on a property, and let's say you got $5,000 in due diligence that you hand over to the seller, they didn't give you the RPODs, you're under contract, and within 3 days of being under contract, you terminate under your rights of the Residential Property Disclosure Act, they have to give you your due diligence money back. That is a very specific time that they would have to give it back. Now, the MOG says the exact same thing. It's not if they don't get both. If they don't get either or when they were required, they would have that right. 3 days from the effective date, having not received them, or 3 days from the date that they did receive them, whichever occurs first. Everybody okay out there?
So you said they have not received the RPOs and the MOG. It's not either or, it's both. They have to get both.
If they haven't received one or the other, they have this protection.
Okay.
So even if only one's missing, let's say they get the RPODs but not the MOG, but the MOG was required, they would have the right to back out within that 3-day period. No, we're going to talk about this a little bit more later, time allowing. This is not nearly as testable, but this is where it outlines some of the credits, or should I say the debits of the parties. So responsibility for certain costs for the buyer. Loan costs are always a buyer debit. Appraisal, buyer debit. Title search, title insurance, buyer debit. Attorney fees for the title search, buyer debit. Recording the new deed, buyer debit. Recording the new deed of trust, buyer debit. We'll talk more about this later. I don't want to focus on that here. Lead-based paint disclosure. Folks, when are we required to provide a lead-based paint disclosure?
Before
Prior to 1978, right?
Yeah. For properties that were built prior to 1978. Okay, so there's this little checkbox. The property is residential and was built prior to 1978. So that's where you attach that lead-based paint hazard addendum. What you got, Dora? Oh, nothing.
Sorry, I responded. Sorry.
Yeah, you're good. This is just talking about, the things like HOA dues, fuel tanks. That's not going to be testable. Seller's obligations. I will tell you that the seller obligations do include conveying clear title. So if a seller cannot convey clear title, or that right to ownership, then they would be in breach of contract. It also requires them on the 2T, specifically this form, to convey by way of a general warranty deed, right here. Good title, general warranty deed. So there are ways to not convey by way of a general warranty deed, but not if you use this form. The 2T says general warranty deed. Remember we talked about the kind of tiers of warranty. There's different deed types. Just some quick notes here. You have to provide access to the buyer to do their due diligence, to do, evaluate any repairs during due diligence, do a final walkthrough. Removing the seller's personal property and trash is part of their obligations. This is where it talks about excise tax. Remember, excise tax is also called what?
That's your. Oh wait, no. Is it a sales tax?
It is, but we don't call it that.
The transfer tax.
Transfer tax and the outdated word for it.
Excise.
That's not the revenue, right?
Revenue stamps. There you go. Excise tax, revenue stamps, and transfer tax. All of those are the same thing. And so this is where it talks about seller shall pay for preparation of a deed, so that deed prep, and all other documents necessary to perform the seller's obligations under this contract, and for state and county excise tax. There you go. Now, I don't think they're going to talk about this. Any deferred, discounted, or rollback taxes. Basically, if you had some kind of conservation agreement that says that you were exempt from taxes or weren't having to pay the full rate, as long as you didn't sell it for a period of time, and then the seller sells it, they would be responsible for paying those back taxes if they, broke this agreement with the government. That's what that's talking about. Agreement to pay buyer expenses. This is where we are dealing with, a negotiation where the buyer says, I want you to pay $2,000 of my closing costs or whatever it may be. We can negotiate that on here. That would be it would be a seller debit, buyer credit, right? We're taking money from the seller, giving it to the buyer because we've agreed to this. That's not important. That's not important. Prorations and adjustments. Folks, I told you when we're dealing with prorations and adjustments, the default in North Carolina is the seller owns the day of closing. So here's what it says. Unless otherwise agreed, the following items shall be prorated, with the seller responsible for the prorated amounts of any taxes and dues through the date of settlement, and the seller entitled to the amounts of prorated rents through the date of settlement, and either adjusted between the parties or paid at settlement. So in other words, good, bad, or otherwise, we give the seller the day of closing. If we're dealing with taxes, that means they have to pay for that day. If we're dealing with rents, that means they get to keep the profits from that day if it's an investment property. Does that make sense for everybody?
Yeah.
You cut out on my screen.
Yeah. If we are dealing with the default, the seller owns the day of closing, good, bad, or otherwise, which means if we're dealing with taxes, the seller would be responsible for paying the taxes that are, include that date of closing. If we're dealing with rents, that means the seller would be entitled to keep the profits from that date of closing. So the first of the year or month, depending on what we're prorating, up to and including the day of closing, is the seller's by default. I'll give you a couple examples of this in just a second. I will go off on a mild little math tangent here to help you understand something. But first, when we're talking about the things that are typically prorated, taxes on real property, your ad valorem tax for real property, paid every year, prorated at closing. Taxes on personal property. Well, hold on. We're talking about selling real property. When might we be dealing with taxes on personal property?
Trade fixture.
Could be trade fixtures, maybe. What else?
Would it be like something on the land, like a silo or a
Mineral
I
rights?
can't think of the word.
Maybe a silo.
So I was going to say they were going to buy the seller's motorcycle.
Maybe. There's one very testable one we talked about that y'all aren't spitting out.
He says easement.
Say that one more time.
I don't know what it is. I'm blanking. Said easements, but I'm wrong.
Manufactured homes. Manufactured homes start as what? Personal property, which means they have a VIN number just like your what?
At the DMV.
Your car, which means if we are conveying a manufactured home and your land conveyance that's still considered personal property, we would prorate the personal property taxes on it. If it's been converted to real property, then it's just the real property ad valorem tax. But if it hasn't been converted, we're going to prorate that one. Not to be confused with modular, which remember is real property from the word go as soon as it's put on a foundation. We talked about that early on.
It's the same as mobile homes, right?
Yeah, mobile home and manufactured and trailer, all the same thing. Modular, something different. There you go.
Quick question on those mobile homes. Isn't once the wheels get taken out and get set on the foundation, it changes, right?
You're missing a step. Remove the wheels, axles, and hitch. Put it on a permanent foundation on land that you also own and file an affidavit of conversion with the DMV, meaning you cancel the title and you are no longer treating it as personal property.
Okay.
Yep. Folks, let me just introduce a math concept because we were talking about the proration math earlier today. But let me introduce something to you, okay? I told you the default proration calculation is your 360-day year, 30-day month. But they could, on the test, give you a 365-day or an actual calendar month. They would have to tell you that, but they could. So let's do two things. I'm going to show you how this works with a 360-day, 30-day, first, and then a real calendar. I want you to think about an investment property from a mathematical point of view. Let's say that you were selling a home that was a rental and you had a tenant in place and you were getting, I don't know, $2,200. Oops, that's not where that goes. $2,200 a month for rent. And then we go on to say it is closing on January 22nd. I want you to think about this. Closing on January 22nd, we're dealing with rents. Folks, where is that rent money right now? On January 22nd, where is it?
It's with the seller.
It's with the seller, right? There you go. Because the seller is the landlord and rents are paid in what we call advance. You paid January 1st to live there for the month of January. So the tenant has hopefully already paid their rent to the seller, who is the current landlord. Well, folks, if it's closing on January 22nd, who will be the landlord on the 23rd?
The buyer.
The buyer. Okay? So that means that the seller's already collected the whole month's rent of $2,200. That's not really fair for them to keep it, so we have to make it fair. So what do you think this might look like on a closing disclosure?
You would credit the buyer the 9 days. So you would take the 2,200, divide it by your 31 days, and then credit the buyer the 9 days.
Love it. Now let's start with the 30-day month first, okay? I'm going to show you both ways. Yeah, there you go. So we're going to, because remember, you could be tested on a 365-day year or a 360-day year. So let's go with the default one first, 360-day year. So if you've got 360 days, that is 30 days in each month. So we're going to say that this month of January has 30 days. So you take your monthly rent of $2,200 divided by 30, and that gives you your per diem of $73.33 a day. How much you are entitled to keep as a landlord. $73.33 a day. We're not done yet. Everybody okay with that first step?
Yes.
Monthly rent divided by the amount of days to figure out how much somebody gets each day. Now, the seller is entitled to the 1st of January up to and including the 22nd of January. And so the easiest way to figure out the buyer's portion, 30 days in this, minus the 22 days the seller's entitled to, gives us 8 days. 8 days that the buyer's entitled to at $73.33 a day. Now, folks, think about this. The seller is selling this property, and they're about to make a boatload of money, probably. The $2,200 is already in their personal operating account. We're not going to ask them to bring money to closing. What we're going to do is just take that money from their proceeds. So the way that this would show up on a closing disclosure would be a seller debit of $586.64 and a buyer credit of $586.64. We are basically taking the money from the seller that they're not entitled to keep and giving it to the buyer, who is technically the new landlord, on the 23rd. Everybody okay with that statement? Prorations are always about making life fair. And this is where I told you, good, bad, or ugly, the default is give the seller the day of closing. Now, folks, I can't stress this enough. On your state licensing exam, just do what the question tells you to do. Don't think you're smarter than it. Sometimes the questions will tell you that we want you to give the buyer the day of closing. If it says that, do that. Don't overthink it. Do whatever the question tells you to do. But if it doesn't tell you, I'm teaching you the defaults. Everybody okay with that statement?
Can you say the default one more time, honey?
For the default, the seller owns the day of closing, good, bad, or otherwise. Taxes, rents, HOA dues, if it doesn't tell you who to give it to the seller. But sometimes it will say something opposite of that. It'll say something like, well, the buyer is going to get the day of closing. And then you just calculate it like that. Yeah. So let me just show you the difference, okay? Because this was the 30-day. So if we had done instead the 360-day calendar, okay? Let's just show you what it looks like different. Now, they would tell you if you're doing the 360 or 365. So if it's a 365-day year, that's a real calendar year. So you would take your $2,200 a month and now divide it by 31 days, which January actually has, which would change your per diem to $70.97. And then now for the days, there are 31 in January minus the 22nd. It would be 9 days. 9 days times your $70.97. Your answer would be $638.73. Still a seller debit, buyer credit. But you could be tested on both the 365-day and the 360-day because they're sick and disgusting people who write this test that you have to take. The default is 360. It would have to tell you that you're doing 365. Now, understand that rents are typically paid monthly. Real property taxes are typically paid annually. And if we ever calculated prorations for HOA dues, buckle up, buttercup. They could be monthly, they could be bi-monthly, they could be biannually, they could be quarterly. And so it's all the same math, just different payment time frames. So just follow along. Say what?
You could have two.
Yeah, you could have two. Now, hopefully they're not going to get that mean on the test. But yeah, it could, you know, in the real world, you could have two. Here's where I'm going to get into the last big testable things, okay? And the next couple things, just like due diligence and earnest money, I think are, extremely testable. Do you remember when I told you if I said a sales contract in general, destruction of the property would kill a sales contract in general, but it would not kill this one? Here's why. Condition of property / risk of loss. Condition of the property at settlement. If the property is not in substantially the same or better condition at closing, as on the date of this offer, reasonable wear and tear accepted, buyer may terminate this contract by written notice delivered to seller, and the due diligence fee and earnest money deposit shall be refunded to buyer. So here's time number 2 that the buyer is entitled to get their due diligence back. So let's say that there was hail damage on the roof and it wasn't fixed. They could terminate because the house is not in the same or better condition. So this means something happened to the property after you went under contract prior to closing. You could terminate and get your money back, or if the property is not in such condition, the buyer does not elect to terminate this contract, buyer shall be entitled to receive, in addition to the property, the proceeds of any insurance claim filed by seller on account of any damage or destruction to the property. So they could elect to move forward and be entitled to the semi-destroyed property and in the insurance money. Kirsten, you got a big look on your face like you're processing something.
So if the house catches on fire and say you get $295,000, and the buyer decides to go ahead with the sale, then the buyer receives the $295,000 in full.
Yeah, whatever the insurance is willing to do. Now, here's the thing to understand, though. Most buyers are getting a what? A loan. And banks are not going to lend on a burned down property and an insurance policy. So most buyers will have to terminate and just take their money. If you're a cash buyer, not a problem. You can take the insurance money. But banks are not going to fund a loan on a burned down property and an insurance policy that's pending. Did you figure it out, Kirsten? Yeah.
Yeah, I just had to read that paragraph a couple times, but I'm good.
Okay. So, is it common for people to move forward if the property gets destroyed? No. And reasonable wear and tear accepted basically says you can't terminate because the carpets are a little more matted. Okay, that's reasonable wear and tear. But hail damage, fire damage, flood damage, anything like that would give you the right to back out because the property is not in the same condition as the time that you put the offer. Now, here's the other really testable piece of this and one other thing that's going to come into play here, okay? Let's start with this one. The risk of loss or damage by fire or other casualty prior to closing shall be upon the seller. Seller is advised not to cancel existing insurance on the property until after confirming recordation of the deed. Folks, you will absolutely get very testable insurance questions in regard to this. So it is the seller's house up to and including the time that the deed is recorded. So if the house was to catch on fire on the day of closing, prior to the deed being recorded, it's the seller's insurance policy that has to pay for it. If the deed is recorded and it catches on fire, it's the buyer's insurance policy that just kicked in that would have to cover it. Because I'm telling you, in North Carolina, we don't consider you the owner. So you will get insurance questions. Seller needs to maintain property insurance all the way until it's recorded. Because it's still their home. Now, there's another insurance piece that'll come up in a second. What you got, Adriana?
Well, it just came to my mind. If on the day that the buyer have the walkthrough, he will walk through with the broker, right?
Yes.
And suppose that on that day, he notices smoke smell. Would that be a reason for him to breach out of the contract? Would be acceptable?
So that's a good question, but here's the thing I can give you. If there was a new smoke smell that was definitely not there before, and it's not a temporary one, sure, because that could arguably mean that the property is not in the same condition as the time you put the offer. Now, if you just missed something when you put the offer in, for instance, you walked through real quick and you didn't realize that a window is broken, you do not have the right to terminate because, oops, I missed this. So it would have to prove that it was a new occurrence that makes the property not in the same condition.
Because the seller, like you say, they don't need to tell that. Oh, I smoked in the house, right?
No.
But anyone that does not smoke would feel the smell. But maybe they put some candles on and fresheners and try to mask the smell, have the house cleaned or something like that, and then on that day, they kick the bucket, and they are like, oh, it's sold already, so they don't care, So that's what I'm thinking. If they notice that smell, if they can back out.
Yeah. Now understand that this is a very specific scenario, and yet again, this is why we have attorneys. You will not be tested to that degree. But arguably, with the right attorney, could you get out? Sure, maybe. If you missed it, maybe not. But I will tell you right now, there's not a single amount of candles in the world that can hide smoke. You will smell it. The only way we can get rid of actual smokers, and even that is subjective, rip out the carpet, put kills on the floor, kills on the wall, repaint the entire thing, run an ozone machine through the ductwork for about 72 hours to a week, and even still you can kind of smell it. So a couple candles ain't doing it. Same thing with cat pee. Not really doing it.
So that would be depreciative for the house.
Sure, absolutely. If you're a smoker, smoke outside. Definitely do it. It's very expensive to try to remedy that. So I'm going to talk about another insurance piece in a second. Here's another extremely testable thing, okay? Let me circle back around. What does time is of the essence mean?
Exact time, exact
Saying
day.
that it has to be done in.
Yeah, no wiggle room, right? No wiggle room. The date is the date is the date. The time is the time is the time. Well, folks, this section right here talks about a delay in settlement / closing, meaning the settlement meeting and the closing date. We agreed to what the closing date is at the beginning of this contract. Remember, we put that on there. What was the settlement date or whatever? Well, this is not a time is of the essence concept. In fact, there is a 7-day delay, very testable, built into this contract. If you are putting forth your best efforts to get to closing, but you can't yet, you are not considered in breach of contract until after 7 days beyond your settlement date. So this paragraph shall apply if one party is ready, willing, and able to complete the settlement on the settlement date, called the non-delaying party, but it is not possible for the other party to complete the settlement by the settlement date. We call that person the delaying party. In such event, the delaying party shall be entitled to a delay in settlement and shall give as much notice as possible to the non-delaying party and closing attorney. If the delaying party fails to complete settlement and closing within 7 days of the settlement date, including any amended settlement date agreed to in writing by the parties, then the delaying party shall be in breach, and the non-delaying party may terminate this contract and shall be entitled to enforce any remedies available to such party under this contract for the breach. Now, a couple things here, and then I'll get your question, Jacob. If you are actively trying to get to closing but can't, and let's say that your closing date, let me just make it easy numerically speaking, your closing date is supposed to be March 7th. Okay? And you can't close, and it comes the 8th, the 9th, the 10th, the 11th, you're still not in breach. You have all the way up until March 14th. As long as you close by the end of the day on March 14th, you're not in breach of contract because that 7 days is built in because you are putting forth your efforts to get to closing. Now, once you don't close on the 14th and the 15th comes, you're past your 7 days, but please understand that the contract does not magically terminate. Now you're just in breach. Breach would give the non-breaching party the right to terminate, but it never happens automatically. Understand the seller or the buyer could be the delaying party. Doesn't have to be one or the other. Maybe the seller's trying to clear a title defect, so they're in delay. Maybe the buyer's still trying to get clear to close, so they're in delay. Doesn't matter who it is. But if we get to that 8th day, the non-breaching party can either continue to wait and give you more time, or they could terminate because you are technically in breach now and be entitled to whatever remedies they are entitled to. What you got, Jacob?
Okay, so say buyer is running late or something, and for some odd reason can't close day 1, 2, 3, 4, 5, and then is saying, I'm available to close day 6. And seller's like, oh, well, I could have closed day 1, 2, 3, 4, and 5, but I can't close day 6 or 7. Who would be in breach?
That's a rabbit hole question. Don't worry about it.
Okay.
I mean, at the end of the day, understand that sometimes when we're not sure who's technically the delaying party now, we would just come to a mutual agreement because I told you, the contract doesn't automatically terminate just because we hit past 7 days. So if the seller's like, no, I can't do that. Let's just move it to this date. We could both agree that day 17 was okay, right? 17 days after, as long as we were all in agreement. But yet again, the default is you got 7 days before you're in breach. Once you're on day 8, technically you're in breach, and they're not going to try to trick you with who's the delaying party. It's going to be the obvious, right? So understand, oh, go ahead.
I'm sorry, and maybe you said this and I just missed it, but settlement date is the same as the closing date, correct?
Yeah, settlement and closing are technically different things, but the date's the same. Because the idea is settlement's the meeting where you sign all the papers. After you sign the papers, closing, which is recordation of the deed, typically happens about an hour later. It happens on the same day. Good question. Yeah. So when we're dealing with this contract, okay, I want you to understand something. I told you what an amendment is. What is an amendment?
Amendment is
A change to a contract.
There you go.
an existing contract.
An existing contract, okay? So we have a contract, and let's say that on the contract that is executory, we have the closing date as 3/14. Well, I just told you you would technically have up until we have it as 3/7. We would have up until 3/14 to close without being in breach as a delaying party. But here's an important thing to note. We could, if both parties agree, amend the contract and actually change the closing date. So let's say that we both agreed, okay, well, let's just mutually agree that instead of 3/7, it's going to be March 10th is our new closing date. Because the date changed, this 7 days changes with it. And so now you would have until the 17th without being in breach. If you agree to change the closing date, the 7 days runs with it.
If you change the date, let's say after the 7th, same applies, right? It doesn't.
Correct. If let's say that it was on like the 9th and you're still within your delay period, but then everybody agrees to change it to the 10th on the actual contract by way of an amendment, it would automatically create that 7 days past the 10th. Yeah. Now, just a couple more really testable pieces I'm going to get into, and then we're going to move on into bigger and better things because we've got to, because time waits for nobody, and this class has a lot of information. So go take a break, come back at 8:40. Whoop, whoop. So, we are currently in the offer to purchase and contract standard form 2T, and we just left off at the delay in settlement provision, which has a 7-day delay in settlement built in, where we are not in breach within 7 days of the scheduled or proposed settlement date. If you go past that, you would be in breach, but please understand that a breach does not automatically terminate the contract. That's very important, very testable, okay? Breach will never terminate the contract because all parties could agree to not go after each other and give more time. But the non-breaching party could elect to go after the breaching party and be entitled to all the remedies therein. Okay? So let's get into the next very testable piece, as I imagine, in this contract. This section right here dealing with, excuse me, possession. No, not the charge that you get for drug paraphernalia. I've used that joke in the past. Possession is occupying the property. You move in. So there's this provision where we are talking about when is possession going to happen. The default is after closing. Possession, including all means of access to the property and transferable amenities and services, keys, including mailbox keys, codes, including security codes, garage door openers, electronic devices, etc., shall be delivered upon closing as defined in paragraph 1M unless otherwise provided below. So there's a couple options here. So the first one says a buyer possession before a closing agreement is attached. So if I say buyer possession before closing, what does that mean is happening?
That's what I did. I moved into my house before my actual closing date.
So what did that make you?
Technically, I was like a renter.
A tenant.
Closing date.
You were a tenant. And so that means the seller is a what?
The landlord.
The landlord. Folks, here's the most testable piece of this. Aside from knowing that this can happen, it's knowing who needs what type of insurance. The seller is still the owner, so they would need to maintain homeowner's insurance, and they would need to make sure that their policy allows them to have a tenant in place. Stephanie, what type of insurance should you get as a tenant?
A renter's insurance.
A renter's insurance policy that covers her personal property. Very testable.
Yeah, because when we bought our property, it was in foreclosure and bankruptcy. But we weren't told that it was in bankruptcy when we first started. So we moved our closing date like 6 times because we had to wait for it to be approved by the bankruptcy judge. So my realtor finally just told them, well, they've already sold their house. They don't have anywhere else to go. They need to move in. So I moved in on June 1st, but I didn't settle our paperwork until July 29th, I think it was.
So 2 months you lived there as a tenant. Now, imagine what would have happened, though, if the deal didn't go through. It would have been bad. It sure would have. Because then you would have had to move again. Yeah. So,
if I ever move again, I'm starting over fresh. I'm not taking anything with me. I already told my husband, if we move, wherever we go,
preach.
I'm not packing no boxes.
Yeah, I'm with you. Listen, it's one thing when you're like young and like single or like, you know, with no kid. You don't even have that much stuff. So like it's doable because you got a couple buddies and some beer and you can move your stuff. When you got kids or you've been living in the house for a long period of time, you accumulate so much junk. It's just not even worth it. Listen, burn this house down before I ever move. Don't tell the insurance company I said that. I'm just kidding. I'm kidding.
This meeting is being recorded.
That's right. Oh, awkward. I'm just kidding. I would never. It's insurance fraud. Insurance fraud is bad. Okay. So let's talk about the other one, folks. We just talked about a buyer possession before closing. That means the buyer moves in before they own it, and so they're a tenant. The seller is the landlord. Okay, well, here's the opposite. A seller possession after closing agreement. What does that mean?
It means the seller is staying there after you closed. So, like, say you're closing June 15th, but the seller needs to stay to July 1st.
There you go. So that means we close, the buyer becomes the owner, and the person who was the seller stays living there. But now they are a tenant because the buyer owns the property. So that means that their homeowner's insurance policy just got canceled because they're not the homeowner anymore. Which means the sellers need to turn around and get what? Renter's insurance. And the buyers need to make sure that their brand new homeowner's insurance policy allows a tenant to occupy it. Does that make sense? Very, very testable. I got this gut feeling that they are going to test you on this. Okay? Trust me.
But we don't have to know the form numbers, right?
Nope.
We just need to know what it actually
You just need to know if they say a seller possession after closing, you would be able to have to process that. Okay, the seller is now a tenant, and you'd have to be able to walk through that and then answer any questions on it.
Okay.
Yep. What you got, Kirsten?
Just to make sure I understand, so whoever becomes the landlord, you said that they need to make sure that their insurance allows for tenants?
Yeah.
Yeah, because some insurance policies may not allow somebody else to live in the house. It depends. It's not an automatic given. Most are okay with you using tenants, but sometimes you may need additional coverages or, you know, depending on your base policy. So you just want to make sure that your policy as a homeowner does allow somebody other than yourself to occupy it. Yeah. So the homeowner's policy would cover the structure, but if the tenant's living there, that's not going to cover their personal property. That's why they would need a renter's policy. Yeah. Now, folks, here's that word addenda, okay? I told you that an addenda is the plural of the word addendum, and these are documents that we can add on to cover more detail in this contract. There are a lot of them. Now, folks, I'm not going to be able to go over all of these because I doubt they're extremely testable, but I'm going to give you a quick rundown on each. You ready? The additional provisions addendum is a document that's used to do 7 very specific things. One of which is to put an expiration of offer. Remember when we told you an offer could self-destruct? You can use it for that. The only other thing that it's really used for that you might need to know is you could use it to negotiate repairs as part of initial contract formation. Probably not going to be tested on it though because it's kind of a complex thing. Additional signatures addendum. If you didn't notice, there's only a place for 2 sellers, 2 buyers. If we've got more than 2 sellers, more than 2 buyers, we would attach an additional signatures addendum to get the signatures of the additional parties. Backup contract addendum is utilized when a house is already under contract and you want to sit in a secondary position that says if the deal falls through from the first buyers, we will take over and we will become the new buyers. It's called a backup contract or backup contract addendum that can be added to this. FHA VA financing addendum is attached when you are getting financing from an FHA or VA loan. Basically, all it does is protect you for appraisal issues. If the house doesn't appraise, you can terminate and get your earnest money back. Not the due diligence, the earnest money. So let's say that this appraisal comes back after the due diligence period where you normally would have forfeit your earnest money. You could get it back if you had an FHA VA financing addendum attached.
So that's the third one when you can get it back?
No, because that's just earnest money. So what I was talking about numerically speaking was due diligence money only. There's 4 times. I'll give you those in just a second. I've given you 2 so far. Loan assumption, the lead-based paint, that is if the property was built prior to 1978, where the seller says, yes, I do know, or no, I don't know about any lead-based paint hazards or whatever. Loan assumption is if you're going to take over a loan, nothing too crazy there. I told you this form is not designed for new construction, resale only. But if you utilize it in conjunction with what we call a new construction addendum, under certain circumstances, it would be suitable for some new construction. But there is an offer to purchase and contract new construction. Now, folks, I'm telling you this, none of this stuff is testable to an extent that you need to be worried. It's too in-depth, but I have to make a brief mention just so you know that you've heard this before. Seller financing addendum, short sale addendum, vacation rental addendum. The vacation rental, we'll talk more about in the property management section, so I'm not going to go into any of those. I don't want you to hurt your heads on them. They're not going to be that testable. Just have a general understanding that these things exist. Most of them are overly self-explanatory. They're not going to test you on the specifics. Too much information. Not possible. The entire agreement / recordation, what this is stating, folks, is that this agreement is the agreement and nothing outside of the agreement is admissible. And so that's the parole evidence rule in action. Only what's in the written agreement is part of the agreement. The other part says recordation. I told you we've got the statute of frauds, which deals with certain things needing to be in writing to be enforceable in a court of law. And we've got, what's the other one that deals with recordation? Not the statute of frauds, but which one deals with recording it to protect your interest?
Recording the deed?
Well, there's the Connor Act, the law that deals with recording. So there's certain documents that need to be in writing to be enforceable in a court of law. There's certain documents that need to be recorded to protect your interest against third parties. Statute of frauds deals with writing. Connor Act deals with recordation. So I told you, oddly enough, contracts for the sale of real property are mentioned on both. However, we seldom, if ever, record our sales contracts. Why? For buyers and sellers, the ability to go to court and enforce them on each other is enough. So this basically states if we're going to record them, we need to agree that we're going to record it. That's all the second part says on this. Conduct of the transaction, computation, none of this is crazy. So here's the thing. Computation of days and times, calendar days unless stated otherwise. Times are in the North Carolina time zone. So that time is of the essence, always going to be North Carolina time on this 2T. Here's the last really important piece, okay? We talked about remedies. The generalization of remedies for contracts. Here's the thing, though. You need to know the very specific remedies that buyers and sellers are entitled to if the opposite parties breach. So if a buyer breaches, in the event of a material breach of this contract by the buyer, seller shall be entitled to any earnest money deposit, the payment of any earnest money deposit, and any due diligence fee to the seller, without regard to their respective amounts, including zero, together shall serve as liquidated damages, there's that word, and as the seller's, this is important, sole and exclusive remedy for such breach. Folks, what does sole and exclusive mean?
They can't try to get more punitive
They
decisions?
can't get anything else. It doesn't matter if you breach one day after due diligence or the day before closing. It doesn't matter how bad the breach is. If you breach as a buyer, the only thing the seller is ever entitled to, due diligence and earnest money. That's it. Now, that doesn't mean that they can't sue them, but the lawsuit would be to recover due diligence and earnest money that the buyer didn't willingly hand over. So don't confuse this with they can't be sued. They can, but only for due diligence or earnest money. So think about it. If the buyer terminates the day before closing and it's after the due diligence period, who is entitled to the due diligence and the earnest money? Say it again. The buyer terminates the day before closing and after the due diligence period, who is legally, lawfully entitled to the due diligence and the earnest money? The seller. Now, if the buyer says, do not give them the earnest money or else, what would the escrow agent have to do?
Hold on to it or take it to the court and
Continue to hold it. There you go. Continue to hold it until all parties agree to its disposition, or alternatively deposit it with the appropriate clerk of court. Here's the point. If there's this dispute, the seller could sue the buyer in court to force Judge Judy to make them pay the earnest money. But that's the only thing you can sue them for. Payment of due diligence or earnest money not willingly handed over. Nothing else will the seller ever be entitled to. This is why I told you on the 2T, the seller could never sue the buyer for specific performance. The only thing they will ever get, due diligence and earnest money. Sole and exclusive. Very, very testable. Everybody okay with that statement? So here's where we flip again. If the seller breaches, in the event of a material breach of this contract by seller, the buyer may, you got options. One, elect to terminate this contract as a result of such breach and be entitled to the return of both the earnest money deposit and due diligence fee, together with the reasonable costs actually incurred by the buyer in connection with the due diligence. So let's stop there for a second. If the seller breaches, they got to give you back your earnest money, they got to give you back your due diligence money, and they got to cut you a check for every dime you paid during due diligence. If you spent $6,000 on appraisals, investigations, and inspections, they would have to give you all of that back. So they got to pull out their checkbook and reimburse you, compensate you to where you were. Okay? Or you may not terminate, you may elect to move forward. So number 2, elect not to terminate and instead treat this contract as remaining in full force and effect and seek the remedy of specific performance, suing them to force Judge Judy to make them sell you their house. That is available to a buyer on the 2T. So you can either terminate, get all your money back and then some, right? All the costs paid, or you can stay in it and sue them for specific performance.
So you said only buyer, not seller. Seller, all, right?
In North Carolina, when utilizing the 2T specifically, only the buyer could sue the seller for specific performance. The seller could never sue the buyer for specific performance. Now, what this goes on to say is that if we end up suing each other, whoever wins gets their court costs paid by the loser. So this attorney's fees is. And then, of course, we got the signatures of the parties. We got the agency place right here. Remember when I told you if you are a buyer's agent talking to a seller or a seller's agent, when would you have to disclose your agency status?
Immediately.
Initial contact. And so if you actually read into the rule, it says that, you know, if you're talking to a seller's agent, that would be an oral disclosure at first, but would ultimately have to be reduced to writing, most likely where? Right here. So this is where you would say, who are you acting as? The buyer's agent, seller sub-agent, dual agent. Or the seller's agent or dual agent. We would say who we're representing on here. But we don't talk about our money. We just talk about who we represent. That's the 2T. Now, these last little sections are acknowledgement for any monies that exchange hands. They're not technically part of the contract. Oops. They're not technically part of the contract. It's just, hey, if you hand this check to somebody, have them sign acknowledging that the check went from this hand to that person. That's all it is. An acknowledgement of the monies. This goes back to that old car. Accounting. Keeping track of the money. Due diligence went from their hands to my hand to the seller's hands. Seller signed acknowledging they received it. We're good.
Seth, I have a quick question.
Yep.
Back up where if you decide that a fixture is going to leave with the seller and you're riding on the line and you run out of room, do you have to do an addendum to add the paper, or can you just attach it on another sheet of paper, or does it have to be on a legal sheet of paper?
Doesn't have to be on a legal sheet of paper. The short answer is you could just say, see attached paper, and then just send it over, because that's not creating legal verbiage. It's just you ran out of space.
Okay.
Yeah. So that is the 2T, folks. Very specific sales contract in North Carolina. Now, please remember that this is not the only contract that exists. This is a very testable one. This is the most commonly utilized one. Let me show you something here. Oh no. Google Drive wants to cooperate. I went back too far. So if you look at this one, and remember you have access to all of these. So here you go. Offer to purchase and contract new construction. This is a separate contract that's utilized specifically for new construction. So not the 2T, it's called the 800T. There's also the one in regard to vacant lots and land. So if you get a question on, which of the following types of property would the 2T be acceptable for? Townhome resale, single family detached resale, quadruplex resale, condominium resale. None of those new construction though. It would not be suitable for that. Dirt by itself would not be suitable for that either. So let me see the vacant lot and land.
Well,
It's 12.
I'm pretty sure.
Yeah. There you go. Offer to purchase vacant lot and land. This is if you want to buy dirt that you will eventually build on. Not for a developer who's going to subdivide this and turn it into a neighborhood, but buying dirt, to eventually build on, closing on the dirt, and then turning around, that's what this is used for. So, I think we've hit this enough. Probably more than. Is there anything on that page I missed? Never any explicit language. Nope. We got that. Backup contracts. Folks, I told you about those different addenda. Backup contract addendum was one of them. The only time you use that is if a house is already under contract and you love that house and you want to crack at it. You basically get in a secondary position, I told you, that says, okay, if this first buyer falls through, we are automatically under contract with you. There's dangers to it because, of course, you are in this backup position. And folks, it's never a good thing when the houses fall through. The only way this would be good for a buyer is if the first people lost their job and couldn't afford it anymore. Otherwise, the main reason people terminate is there's issues with the house. So very dangerous to be a backup contract position. Please understand, even if the seller is not interested in accepting backup offers, you still have to present it, because remember, we have that delivery of instruments rule in North Carolina. Have to deliver all instruments immediately in no case later than 3 days. Whether the offer is good or bad, whether you're already under contract or not, whether or not it's formatted correctly, you still have to present it to the seller immediately in no case later than 3 days.
You said we have to, what, in 3 days?
Deliver all instruments immediately, but in no case later than 3 days. Offers, agreements, whatever it may be, to the appropriate parties. So, let's keep boogieing along here, folks. I know this is a lot of information, but I'm trying to rush through it because we've got still lots more to cover, and I'm hoping that we can turn around and do some review, later on in class. So you'll have at least heard it once, even though it was fast. I know. It's just so much information. Yeah, I get it. I tell you, it's a lot of information. I mean, if folks think about it, not once have I stopped talking in the entire time we've been together, have I? I have little itty bitty brief pauses, but it just keeps going. Yeah, it is too much information. So these are just some of the different ones that I just referenced really briefly that you could see. They're all available. You're welcome to read through them. They're probably more testable than they were before the testing providers switched because of that question increase, but they're not going to go into the umpteenth degree on any of these. I promise they're not. I already told you what you needed to know about the possession before and after closing for the buyer and the seller. Vacation rental we'll talk more about later. Short sales we'll talk more about later. Lead-based paint you already know, and I already told you the main two things you need to know about the additional provisions and the FHA VA financing addendum. Now, the good news is these next couple pieces are going to be reviewed because I already kind of taught you these as well with that activity we did last week, the do we have a contract activity that you did. So remember, one more time, how do we move from an offer to a contract?
By communicating
Both parties have to have signature, and it has to be communicated that the offer's been accepted.
So who is that communication always made to?
To the buyer's agent.
Don't say buyers.
Well, it could be the seller's agent.
Right. So how do we say that in a way that always means the same thing?
Offer or agent.
Offer or's agent. There you go. You can't say buyer, you can't say seller, because depending on if it's a counter offer or an original offer, it could be either. So it is always communication of acceptance to the offer or the offeror's agent. Yes, we need signature, but signature is just indicative of acceptance. We do not have a contract until you communicate. Folks, what are the appropriate ways to communicate that acceptance?
Email, message.
Phone call, text message,
Fax.
fax, send a letter. You can do any
The
of the.
seller can send the letter, not the
Don't say seller.
offeror.
The offeree or the offeree's agent could send a letter, but that letter has to go to the offeror or the offeror's agent. Remember the mailbox rule. Communication of acceptance is communicated under the mailbox rule as soon as that acceptance communication is in the possession of the United States Postal Service. So you could be under contract if that communication is mailed to the offeror or the offeror's agent. So in other words, communication can happen any which way. And remember, they do not have to actually see the contract. It's enough to be told that they have signed. Because real estate professional to real estate professional, communication in general, it's communicated. I have signed, I have accepted, I have whatever. That's what makes us under contract. So when we move from an offer to a contract, that's the effective date. Due diligence is due on that date, and earnest money on that 2T is due within 5 days of that date. So we already talked about this too. Always material facts, back in the agency section, discover and disclose all material facts to everybody in the club getting tipsy, okay? Clients, customers alike get material facts. I just told you about the delivery of instruments rule. All things have to be delivered immediately, in no case later than 3 days. That is a rule under North Carolina law. Or rule, should I say. A rule under the rules. Now, while I told you communication of acceptance can happen to the offeror or the offeror's agent, please understand that when we are working with buyers and sellers, what tier of authority do we have? Tier of authority, tier of authority, tier of authority.
We're working with both.
Either or. If we are working with a buyer or a seller, you are a special agent. We cannot bind them to anything. We cannot make decisions. So you do not have the authority to accept or reject an offer on their behalf. When we're talking about communication, it's communicating what they have done. Okay, they accepted it. I'm communicating it to you. And of course, the communication, we do stand in the shoes. As soon as we know as their agent, the offeror's agent, we are under contract. And this middle one says only one contract signed by all parties is necessary to be binding. We do not need everybody to have their own signed copy, or, original copies is fine. It can be signed in partials and then copied. It doesn't matter. As long as we all accept it as the contract, it's fine. The existence of multiple offers is not a material fact. So in other words, if I'm a listing agent and I've gotten 10 offers, I do not have to disclose that I've already received 10 offers. Can I share that I have 10 offers already? Yes. If the seller gives me permission. The seller would want to decide if it was in their best interest for me to share that information or not. I'm not legally obligated to, but if the seller thinks it's in their best interest for me to share that information, I could. Now, one step further than this, we kind of talked about this a little bit, I think, already. You are never allowed to share what about those offers?
Any of the details?
The material terms of that offer. You cannot share any of the details. That is prohibited in North Carolina. We have a rule that says you cannot share terms of an offer without permission of the person whose offer it is. Now, please understand that this is where you've got to take things literally as I'm telling you. In the real world, is anybody ever going to give you permission to screw over their offer or? No. But if the test question says it's never possible to disclose terms of an offer in North Carolina, is that a true statement?
No.
No. Never is too strong. It is possible, just very unlikely. I told you, there are very few absolutes in this class. So be very careful of words like never. You could never disclose material terms of an offer is not a true statement.
That's why I'm glad this test is not true false.
It's not true false. It's multiple guess.
Yeah, but most of the time you can.
I know.
Okay, these two answers suck, and you got a 50-50 shot of getting it right.
That's right. So we already talked about the communication. Okay, I'm not going to go through all this again. Has to be communicated to the offeror or the offeror's agent. Remember, we gave you the example last week. If you are acting as a seller sub-agent, you are not the buyer's agent. So if an offer was needing to be communicated back to a buyer who didn't have an agent, you are not under contract until the buyer knows themselves. That agency is important, okay? Offeror or offeror's agent. If they ain't got no agent, they have to hear it themselves.
Seth, before we proceed, I watched your little NC mini course on YouTube, and I seen your baby beard.
My baby beard back before. Yeah, it's funny, Misty. I have had a beard, just on a side little tangent. I used to work as a restaurant manager back in the day, and for the longest time, they would not let us have facial hair. They changed that policy, and so I've had a beard probably since I was 22 at this point. But for Halloween, not last year, but the year before, I went to a party as Guy Fieri, the guy from the Diners, Drive-Ins, and Dives. So I shaved everything except for like the stuff that, like he had. So like this was all gone and I just had like the thing. And so I had to like regrow it all. And so it was very short for, before that. And so this is like the longest I've ever had it, because I was like, well, that's the shortest I've been since I was 22. I might as well see how long I can get it without losing my mind. So.
Well, anybody that knows men with their beards, it's a thing, right?
It's a thing. It's a thing. Now, Jacob, mine wasn't nearly this full at 22. I still had one, but it was not nearly this full. Okay, so yeah.
This is.
It's okay, man.
I'm on like day 4 without shaving.
It's okay, Some people just, it takes a while. Some people just aren't destined to have them. It's all right. Ain't nothing wrong with it, man. It is what it is.
That's not fair. I want a mustache.
Yeah. Eventually.
Yeah.
Justin says guys with beards are worse than women about their hair. Yeah, you're kind of right, Justin. You're not wrong. You know, it's a whole thing. I've gotten into the point now where I'm like, you know, depending on the day, I've got like beard oil that I'm like putting in it and like edging it up. So some days it's a little more chaotic. Other days, you know, yeah. I thought you were going to say that the review was helpful.
I was like, oh my goodness, look at Seth.
No, see, I really thought you were going to be like, oh, it's such a helpful review. And you're like, nope, baby beard. It's okay. It's all right.
Definitely gonna start watching that review like once a day.
I will try, now that I'm back home, I've got my big PC down here that I use for my editing. So I'm going to try to get all your other videos rendered and uploaded. I've got probably a half a dozen old school pre-licensing reviews, probably a dozen actually, that are like anywhere from 2 to 4 hours. I'll try to get some of them edited and put up on that YouTube channel as well, and I'll let you know when I post them, just because I cover different things in different ones. But, you know, editing just takes so long with all the other things I have going on. But I will try to get some more up for you, you know, so y'all can review them probably this week as I kind of edit the other stuff. And I'll share the Zoom links until I get everything edited, so. Yeah, we're good on this. Folks, the inbox rule, this is not talking about the mailbox rule, but basically when we're dealing with things that are time-stamped, it's considered communicated at the time that it hits their inbox, okay? It's, even though they haven't seen it, if you send an email, it's time-stamped. It's been communicated. If you send a text, if you send leave a voicemail, all of those are time-stamped, and so they are communicated at the time that they are sent to the party who needed to receive it. What you got, Jacob?
I have a really interesting story about all of that happened to me the other day at work.
Go ahead.
So I had two people that came in. They both wanted the same house, and one of them. Okay, so client A and realtor A came in. It was their first time there. Showed up in the house. Whatever, they really liked it. The clients left, and the realtor stayed for some reason. My 2 o'clock appointment comes in. They are saying, you know what, yeah, we're ready to go ahead, move forward, everything like that. And then realtor A calls me from the other room. She goes, Jacob, come over here. While I'm in a meeting with these clients, like, they're getting ready to move forward to the house. And she's like, my clients just sent you an email offer, blah, blah, blah. And the way that we do it is we're first come, first serve. And so it was just really interesting how everything was playing out, because there's the logistics of, okay, well, they verbally told me, but there wasn't a written, like, thing. And so it was just a super weird, super uncomfortable situation. But it happened the day after we were talking about, like, this stuff. And so it was crazy.
So yeah, I wonder if that's why that real estate agent stayed behind, because they saw people walking in and they're like, let me just make sure they're not after my client's house that they like. And as soon as they heard it, they probably texted their people, you need to tell me what we're putting in for terms right now, and we need to send it over, because they didn't want to get beat out on it. That does happen sometime.
Yeah, but we ended up giving it to the ones that had an appointment instead.
Shoulda, woulda, coulda, right? I mean, it's just an offer. It's not a contract, right? So offers can be rejected. As the seller, every right is whoever you want to take, right? Let's take a look at this one, folks. See how you're feeling on this. Which scenario best represents a legally binding contract once a seller submits a counter offer to the buyer? Well, you know, there's some uncertainty. There's some answers out there, but there's a lot of quiet people, right? Like, everybody's like, I'm not saying nothing. I'm just saying, okay? Yeah, folks, you gotta read these things quite literally, okay? So the seller submitted a counteroffer, so that means the original offer died. Now the sellers are the offeror, the buyers are the offeree. Well, Option A says buyer's agent emails the seller to advise them that their client intends. That's not the same thing as signing and communication acceptance, okay? Intends is not a contract. So that is not A. The seller receives a digital signature of acceptance from the buyer. Are they aware that the buyers accepted their counteroffer at that point?
Misty.
Yeah, you got to be careful, all right? Intends isn't strong enough. So B is the answer. B. How about this one? I'll let you read it. Tell me what you think. Cool. So, true or false, Jimbo buyer submits an offer through his agent Frank of Go Realty to the seller's agent Jolene of XYZ Realty. Seller likes the offer and signs into the presence of Jolene. Before Jolene can take further action, Frank of Go Realty calls to rescind the offer. Does this legally terminate the offer? That is
Yes.
yes. Because it was
Hadn't had a chance to tell the buyer that it was accepted.
There you go. Communication has not occurred, and so that means that you can rescind any time prior to unconditional acceptance. So folks, I'm going to give you a couple more, and then I'm going to give you some very important and powerful insight because I think at this point you can handle it. So here's another one, okay? What do we have if Jolene emailed the contract acceptance to Frank before he called to rescind the offer?
Then they have a contract.
They have a contract.
Contract.
Because then that communication of acceptance happened before the revocation. So that absolutely would be a contract. Now, here's one thing that I need to give you some caution on, okay? We're going to go back to this scenario. Whether you realize it or not, this is important. XYZ Realty and Go Realty. So that means there's two firms. That means there's exclusive representation only. Folks, if this had been Go Realty and Go Realty, we would have had a contract. Why?
Right. Because it would have been dual agency.
It would have been dual agency. So when they signed in the presence of Jolene, Go Realty knew, which meant that it had been communicated to the offeror's agent because Go Realty is the agent of the buyer and Go Realty is the agent of the seller. Be very careful on contract formation questions dealing with dual agency. If it's the same firm, you default to that worthless crap where everybody represents everybody, and if one person knows, the agent knows. Now, to contradict that, if it then thoughtfully said that Frank was the designated agent of the seller and Jolene was the designated agent of the buyer, it turns back into no, there's no contract. Because when there's designated, it works just like the exclusive communication. But if it doesn't say designated, either or knowing would have created a contract. Does that make sense?
Yes.
That's advanced crap. If you're feeling good, then good.
Jacob, it is testable. You just have to be careful with the word.
That is testable. I'm not going to say very, but it is testable.
Well, it makes perfect sense. It just
It sucks.
Like a lot of room for accidental error.
Absolutely, which is why your thoughtful instructor is taking time to warn you about the accidental errors I see on all the test taking. There you go. I've seen it, you know? I've got to warn you. I haven't seen the actual test, but I've seen years and years of students taking the different test questions, the quizzes, the practice exams. I see where we mess up. And I'm very intentional to try to warn y'all and caution y'all from making those same silly mistakes. So we already talked about termination of offers. I'm not going into that again. We've already talked about counter offers, due diligence. I'm not going into all this. We got to get into some new and exciting things. You can have this application, okay? You read it. Tell me what you got. So true or false, Wanda Buyer is working with Gina of ABC Realty to purchase a home. Wanda makes an offer on a property listed by ABC. After Gina explains she'll be working with her as a dual agent, the offer is signed, accepted, and communicated to Gina. We now have a valid contract that Wanda cannot revoke. Now, folks, this one was nice to you and gave you extra details to be easier, I suppose, and even included things like dual agent, okay? They will not do that on the test, I promise. So because this offer is signed and accepted and communicated and they are a dual agent, it is a contract because the agent of the offeror is the agent of the offeree as well, which means one party knows, the agent knows, communication to the agent is the same as communication to the principal. We're under contract. Here's another one.
Oh, wait, hold on, question.
Yeah?
I just realized this. So it says that, okay, so Wanda is the buyer.
Wanda's the buyer.
And she makes an offer.
Utilizing Gina.
Who's working for the buyer and the seller.
Never mind.
Now, like I said, this one was nice because it used one agent, one firm, and said dual agent. It would still be true if there was a Gina of ABC Realty and a Samantha of ABC Realty. It wouldn't change this because dual agent means everybody represents everybody. You can never default to designated. We would have to state designated. Everybody okay with that statement? This one had training wheels on it. It was very nice to you. They will not have that on the test. It will just, it will use two agents. They will both be with ABC, and you will have to know it's dual agency because that is what it is. And so if one agent knows, then it is under contract because every agent represents everybody.
There is a question on the practice final exam that says designated dual agent. Just they need to make sure they read it.
That's exactly right. And if it's designated, then it's treated just like that same plane, right? It has to go back to the designated offeror's agent. For designated, it's different. For dual, everybody represents everybody. Words matter. Isn't this fun? Do this one for me real quick. There you go. True or false, buyer pays $1,000 in due diligence and $3,000 in earnest money towards the purchase of a home. The due diligence period expired after 2 weeks. However, the seller commits a material breach by failing to deliver a marketable title. Buyer would be entitled to a refund of both due diligence and earnest money. Yeah, because the seller breached. So that breach entitles the buyer to terminating the contract and getting all of their monies back. Now, yet again, this one was spoon-fed to you. It will not use the word breach in an actual test question. It'll just say the seller could not convey clear title. And you will have to know that's a breach, and you would have to know that the buyer had these remedies available to them. Now, let me point out one last note on the offer to purchasing contract, just because I worry they're going to throw it in as testable. You can handle it now. Folks, if you were to terminate as a buyer during your due diligence period, who does the earnest money, who is it supposed to go to?
During due diligence?
You've terminated during your due diligence period.
Back to the buyer or the offer.
Back to the, well, now in this case, it's just the buyer, okay? You don't need to use offer or offeree here. Back to the buyer. And so here's something that I want you to understand. You have that right to terminate for any reason or no reason because you are in compliance of the contract. Folks, when did I say due diligence money is due?
Due diligence is due when you sign or when you,
Effective date. Here's the last little provision that I want you to be aware of because I worry that they're going to throw this into the new test. This right here talks about what happens if you don't deliver the monies. We all know that if you terminate during due diligence, you would just lose your due diligence but get your earnest money back. If you terminate after due diligence, you would forfeit both. However, there's a problem. If you fail to deliver either of these monies by their due dates, the seller would have to provide you with written notice of your failure to do so and give you one banking day after that written notice. A banking day is Monday through Friday to remedy that situation. And if you did not, they could terminate due to your breach as a buyer, and they would be entitled to both the due diligence money and the earnest money. Even though you have not expired your due diligence period because you never delivered it, you would lose both. Should buyer fail to deliver either the due diligence fee or any initial earnest money deposit by their due dates, or should any checks or other funds paid by buyer be dishonored, check bouncing or canceled, buyer shall have one banking day after written notice to deliver cash, official bank check, wire transfer, or electronic transfer to the payee. Well, that means immediately available funds. Personal check wouldn't be satisfactory. It's got to be something that's immediately available. In the event the buyer does not timely deliver the required funds, seller shall have the right to terminate this contract upon written notice to the buyer, and seller shall be entitled to recover the due diligence fee together with all earnest money deposit paid or to be paid in the future. So if you do not deliver this money, you do not get a due diligence period, and in fact you're in breach after one banking day has transpired from the written notice given to you by the seller. And let's say that you are supposed to give them $1,000 in due diligence and $10,000 in earnest money. Now they can take you to court and go after all $11,000 for your failure to timely deliver funds, even though you normally wouldn't have had to turn over the earnest money to them. The reason they did this, pay the damn money, terminate during your due diligence, you've only lost $1,000. That's why it's very important to understand the second you get under contract, because as soon as you're under contract, you owe the seller the due diligence, and that earnest money needs to go in that escrow within 5 days. I just have a feeling that this somehow made it into the new North Carolina test. Just a hunch. Keep that thing under lock and key. I have no idea. So, I've got just a couple slides left in this section. So here's the plan, folks. I'll give you the last 5 minutes to just talk to me about whatever. But tomorrow night, we will hit the last couple slides talking about what we call exotic or alternate conveyance contracts. Installment land contracts, seller financing called a purchase money mortgage, and then what we call contractual preemptive rights, right of first refusal and right of first opportunity to purchase. Very short, sweet, simple kind of discussions just on what they are and how they can be tested. And then we will dive right in to finance tomorrow. And buckle up, buttercups, because it sucks.
Yeah.
To most people, it sucks, Stephanie. You know, the good news about finance is it's a little more straightforward. There's not as many like if this, then that, if this, then that, if that, then this, if that. There's not as much of that. There's not as much analytical. It's a lot of it is just understanding basic principles of math and functionality. And so I don't need as much time to explain it. You still need to study it to the umpteenth degree, but yeah. Yeah, the most interesting part is the money. Although I will tell you that the money is one of those things where people think that they understand how it works. In reality, most people don't. It works very different than most people assume. And of course, you know, that's why we have financing legislations like the Truth in Lending Act and the Real Estate Settlement Procedures Act. But I promise we will explain it all to you tomorrow.